got a message.
Well, welcome. I'm really just here to say a quick hello. I'm Jennifer Milken, and I have the good luck of being dean here at UCLA Law School. And it's really just my pleasure to welcome all of you here and to participate in this conference, Can Delaware Be Dethroned? I think we here at UCLA are truly fortunate to have a distinguished and quite vigorous business law faculty who's also maintained a close relationship with Delaware's Court of Chancery and Supreme Court. In fact, last month we had a program featuring former Chief Justice Myron Steele. And we also co-sponsored a lunch for current Chief Justice Leo Strachan. So, having now brought Delaware into the room, it's a perfect moment to ask the question, can Delaware be dethroned? Or more generally, to have a conference examining Delaware's place in setting rules and establishing norms for corporate governance. Because I think it's a terrific topic for what we're going to be talking about. And I'm really delighted to see such a great who's who list of fabulous business and corporate law scholars from around the country here to engage with this. I'm an evidence scholar. I know nothing really about corporate law, and even I understand that the doctrinal and practical issues around corporate governance and Delaware in particular, the legislature and the courts, having been the dominant player in this space, is incredibly important set of questions. It's so important that I needed to make sure that there was no sunshine here for you, so that you would not be drawn by the beach or by other Los Angeles pleasures, and instead would stay here and really think hard and solve these important problems. And so thank you for doing that. I'm glad that the floods have not yet started. It turns out that a drought is actually more pleasant on a day-to-day basis than what we have this winter. Now, I want to especially thank my colleague Steve Bainbridge, the really more distinguished professor of law, for conceiving and organizing this conference, and more generally for his intellectual leadership in business law here at UCLA and well beyond. It's both, I think it goes without saying, but it also needs to be said, and I really appreciate, Steve, the way that you not only organized this, but the tremendous thought leadership you brought to the whole thing in all kinds of ways. And I also know that this is going to be turning into an accompanying book featuring all of your papers, and that's really terrific. I'm a big fan of conferences that have an afterlife, where there's something that comes out of it. And so I love that this will be producing this Cambridge University Press book on this. Now I know that Steve also didn't do this alone here at UCLA even for this conference, and I'm really grateful for my other colleagues who've been involved in this conference, as well as all of the contributions they make to business law more generally, including, of course, Iman, Tommy, Jim Park, and Sonny Kim. There's Jim. There you are. Two of them are sitting right here at the table. And finally, I definitely want to thank the Milken Institute for Business Law and Policy and Joel Fuhr, its executive director, who is sitting here as well, which is the financial sponsor for the conference. And the Milken Institute is an academic center here at the law school that supports our business law faculty and our students and the business law specialization, as well as curricular initiatives, faculty research, and really just helps the law school engage with these business law and policy questions in a rich and thoughtful and sustained way, both academically, but also with practitioners, with business leaders, regulators, and policymakers, and has a wide array of activities that they've been bringing to the law school and the broader community. And so I encourage you to ask Joel about what else is going on there and what we're doing. So enough prelude. It's time for you guys to decide whether Delaware can and should be dethroned. So I will ask Steve Bainbridge to come and actually get the conference going. But really, I just want to thank you all for being here. It's terrific to see this excellent group, and I hope you have a wonderful day. So thank you.
Let me add my words of thanks to all of you. It's good to see a lot of old friends again. I got the idea for this conference out of the skirmishes over fee shifting in Delaware, and the speculation that some of us engaged in at that time when we saw, for example, Oklahoma poking around authorizing fee shifting. And I know Chancellor Chandler and Tony Ricky's paper will speak more directly to those issues. But we all know that Delaware has not run corporate law since time immemorial. There was a time when their next door neighbor, New Jersey, dominated corporate law until New Jersey enacted the Seven Sisters and lost their preeminence. And so the question that occurred was, well, could fee shifting be a Delaware sister? And could you accumulate enough for somebody like Nevada, I doubt Oklahoma, frankly, but Nevada certainly has its eye on Delaware. Pennsylvania long has had its eye on Delaware. Could somebody challenge Delaware? And so that led to the idea of having a conference that sort of assessed how Delaware got its predominance, how it maintains it, and whether it faces any risks. And I think, you know, the panels that we have will do a really good job of exploring that. Our first panel today is being moderated by my friend and colleague and now co-author. A little plug, we have a new casebook on mergers and acquisitions that is in final galleys and will be available next year. Make a great Christmas present, even if you don't adopt it for your course. And she'll be moderating. The basic idea here is that we'll take about half of the allotted time for presentations, about 15 minutes per paper. You know, maybe let it slide to 17 or 18, but the moderators have been instructed to, you know, cue the Oscar end of speech music when and as necessary. And then to have extended discussion. We have some real high-powered people in the room. And the opportunity to have discussion amongst ourselves and to engage the co-authors is something that I think, you know, we really want to do. And so the authors have all been told to assume that their papers have been read and that you all will be ready with questions. And with no further ado, I'll thank you again and turn it over to Aman to moderate the first panel.
Thank you, Steve. And on the book, we do have a worthy competitor here in Steve Davidoff, so I'm hoping that we'll reach a conclusion and we can share the market and maybe cooperative federalism will be the way that we settle this debate.
Go states.
So we have a panel today titled Wilmington versus Washington. But for over 200 years now, corporate governance has been largely a matter of state law. Our corporate federal system survived the crash of 1929 and the New Deal with the advent of federal securities law, focusing more on market structure and flows of information than on the internal affairs of the corporation. Now, this morning's panel takes up the question whether the system is under siege as a result of, for example, encroachments from Sarbanes-Oxley, from Dodd-Frank, that point to greater federal intervention in traditional domains of state law, and of the reduced efficacy of boundary lines that once served to stave off federalization. So our first panelist, Sung-Hee Kim, is professor of law here at UCLA and the director of the program on in-house counsel at our Lowell Milken Institute for Business Law and Policy. And her current research interests lie at the intersections of professional responsibility, securities regulation, and corporate governance. Before she became a professor here, Sung spent several years in private practice as a transactional lawyer and with Red Bull North America as its first general counsel. Now, what I'd like to do is introduce the panelists individually and give you a little teaser. This can only work in an audience like this. A little teaser about their presentations. And then once we're finished, we'll take questions. I'll probably start off with a question of my own. Some will be presenting the failure of the federal incorporation law movement, a public choice perspective. And some looks at the balance between the states' dominant corporate lawmaking role and the occasional but notable interventions of the federal government through the lens of public choice theory. During the Progressive era, the effort to adopt a federal incorporation law failed despite favorable conditions, namely an eager champion in President Theodore Roosevelt and a focusing event in the bank panic of 1907. Son's public choice explanation for the survival of our federal system of corporate law in the 1900s also has purchase today. She'll be drawing on it to reveal what it spells for the federalization movement.
Thank you, Iman. So I'm going to assume that most people have read the paper and are familiar with the general debate about sort of the competition for state corporate charters. So, there's been a huge debate whether or not the state-to-state competition for corporate charters. Basically, we're talking about the prize of the $500 million in corporate franchise tax revenue, whether or not that motivates the states to make better, i.e. efficient corporate law, or whether or not it makes for pandering to managerial interests. So is it a race to the top or a race to the bottom? And I enter into the debate, although it's not really my entering into the debate, but I introduce my ideas sort of where Mark Rowe leaves off. So Mark Rowe wrote a series of very influential articles in 2000 and 2003, Delaware's Competition, Delaware's Politics. Basically, he says, and most of you are familiar with his influential articles, he says that it's really not a state-to-state competition, it's really a federal-state competition. In other words, Delaware can be dethroned and can easily be dethroned by the feds. So I thought that was a really interesting intervention. But I wanted to ask the question, why does Congress, i.e. the feds, so Congress and its affiliates, which include the SEC, the federal courts, as well as the New York Stock Exchange, why does Congress allow Delaware to grab the agenda-setting power and allocate for itself and its affiliates only the ex post decision of whether or not to displace Delaware? Why does it allow it to do that? Why not fully take over? Why even permit Delaware to have the first crack at making corporate law? So that is a question not fully addressed by Rowe, although he does have some views about it using his interest group and public choice analysis. And I wanted to apply the same analysis to a period of history to answer that question. In particular, I wanted to focus on one of the three hypotheses that he advances in answering that question. And in particular, I want to focus on the second hypothesis, although I think all three of them are to varying degrees valid. The second hypothesis is, as a historical matter, the serendipitous alignment of interests, policymakers, and scandal just have never been right for the full nationalization of corporate law. So I wanted to explore that hypothesis, but with respect to very specific historical events. So what I focused on in terms of historical events was what I believe might have been the federal government's best historical opportunity to enact a federal incorporation law. And that was, in my opinion, the debate over the Hepburn amendments to the Sherman Act in 1908 during the last year of Teddy Roosevelt's final term as president. I wanted to find out why federal incorporation failed, at least on this occasion, which I believe, and I could be wrong about it, I believe was the federal government's best chance of accomplishing federal incorporation or federal licensing. The Hepburn Bill of 1908 intrigued me because there were many factors that you would have thought supported the accomplishment of federal incorporation. And if you were a betting person, you might bet that the federal incorporation would have happened. Most importantly, it was also Roosevelt's last chance. This was something that was on his agenda since he ascended to the presidency after the McKinley assassination. And this was basically his last opportunity for accomplishing this. So what were the factors that supported federal incorporation being accomplished in 1908? First, there was widespread distrust in large corporations and widespread public belief that only the federal government had the resources to tame and control large interstate corporations. Second, this was very surprising to me, by at least 1902, prominent members of the business community, including from Standard Oil, Federal Steel, United States Tobacco Company, American Steel and Wire, and reputable corporate lawyers, famous corporate lawyers, publicly embraced the idea of federal licensing. They were frustrated by the fragmentation of state laws, and they craved uniformity and greater certainty in the law. They were also frustrated, deeply frustrated, with the Supreme Court's literalist interpretation of the Sherman Act, which threatened to invalidate any restraint of interstate or foreign trade, regardless of whether or not that restraint was reasonable. This was a very clear and dramatic departure from the common law restraints of trade. And big business largely believed that a federal licensing scheme that could displace or override Supreme Court jurisprudence on their contracts and combinations would bring some sanity to regulation. And Roosevelt believed that Congress would accept federal licensing as the proper price of legalizing reasonable restraints of trade. Third, the idea of federal licensing at that time, and I'm talking about the first decade of the 1900s, generally seen as inevitable. The Wall Street Journal said this is an inevitable development. A brand new agency set up by Roosevelt at the very beginning of his presidency, the Bureau of Corporations, had basically worked, campaigned, and commissioned studies to prepare the United States for some form of federal licensing. Finally, almost everyone was unhappy with the Supreme Court. So it wasn't just big business, right? They were obviously unhappy because the Supreme Court was indiscriminate in applying the Sherman Act. Labor was also very unhappy with the Supreme Court. The Supreme Court seemed very anti-labor and applied the Sherman Act with equal force against labor unions. The court had used the Sherman Act to invalidate a labor boycott, and people really feared that the Supreme Court was also going to use it to invalidate strikes and collective bargaining agreements. So this presented a real big historical puzzle for me. All these factors supporting federal chartering or federal licensing, why did it fail? So basically my paper was trying to figure out the answer to this historical puzzle. After performing some research, which I am continuing to do, I concluded that the following factors led to the failure of federal corporation. First, it turned out that a famous Supreme Court decision called Lowell, which was handed down right before, literally 3 weeks before the bill was introduced in the House and Senate, ultimately had the effect of limiting the support for the bill by deepening the divisions between labor and capital. Although the Hepburn bill made concessions to both labor and capital, this particular court case intensified a war between the small manufacturers associations and labor unions. A war that was so intense that the leadership on either side could not plausibly engage in political compromises or else be accused of selling out. So the bill ultimately received only tepid support from labor. What about the small manufacturers? Well, they had strong reasons to support the Hepburn bill. So they obviously opposed the Supreme Court's literalist interpretation of the Sherman Act against what they did. However, they favored the rigorous regulation of large corporations and applauded whenever the Supreme Court would use the Sherman Act as a tool to rein in big business. On the other hand, they perceived their interests being much more endangered by labor than big business. So small manufacturers objected to the bill's differential treatment of labor unions and capital, and they worried that the bill would be interpreted to legalize the consumer boycott. And at the moment, because of the Supreme Court's decision in Low v. Lawler, which basically invalidated the consumer boycott, the labor galvanized boycott, against a small manufacturer. Because they had that in their favor, it was a tool against labor. They didn't want that tool to be taken away from them. So ultimately, they decided to take the tactical position of standing pat on the Sherman Act, and they fiercely opposed the Hepburn bill. So it was probably their opposition that doomed the bill's fate. Another factor that doomed the fate of the bill was the ambiguous status of the boycott. So I looked at the language of the act, which is actually a very short act, it's only 10 pages. It's very ambiguous whether or not the boycott would be allowed under these amendments. And that ambiguity really worried the small manufacturers. They want to make sure that the boycott would be unlawful, and they didn't have that assurance. Another factor that I believe caused the failure of federal incorporation was that the bill just had just concentrated too much legislative and judicial power in the hands of the executive. And this stoked very strong federalism concerns. It wasn't that long since the Civil War. And there was a lot of fear about the unilateral power of the executive as portrayed in the bill. That was actually quite surprising because there's almost no judicial process in the bill. And in fact, there's even very little bureaucratic process. It basically was a bill. Roosevelt felt, he wanted to have the final say on what regulations should and should not apply to corporations. Roosevelt was also very intransigent about maintaining what seemed to be very out of mainstream views. He was a very strong believer in strong executive power, but his philosophy about large corporations was really interesting, but out of mainstream. He felt they were like public utilities or other natural monopolies like railroads, and thus they should, as part of capitalist noblesse oblige, they should be operated to serve the public interest and general welfare. So he really believed that corporations should be lumped together with public utilities and natural monopolies. So he drafted a strong bill that had publicity, had disclosure as part of it, but most importantly, that would potentially regulate prices, for example. This was far too empowering the executive was drafted in this bill. And another problem with the bill was that Roosevelt didn't craft enough certainty. Big business wanted predictability, they wanted certainty, they were willing to sacrifice some freedom to gain some certainty. But unfortunately, this bill, which is only 10 pages long, didn't provide that. They wanted some precise standards to define what would be legal and illegal restraints of trade. This bill was not drafted. It gave no guidance, no parameters, and that really bothered business. So that's basically my point. After thinking about this topic and trying to assess, what are the implications for today, I think it's very interesting because. So Mark wrote in his papers, and they're absolutely excellent articles. He really does make the federal government seem all powerful in one sense, and the reason why he does that is because he wants to emphasize the federal government's ability to trump Delaware. So the looming threat of federal intervention really does shape Delaware's incentives, and I probably agree with that, although I'd be interested in hearing what judges think. And so his emphasis was on the power of the federal government, and so my paper is a little different, I think, in the sense that I emphasize the limitations of federal power. Indeed, the stars need to align. There needs to be an exquisite alignment of interest groups, which didn't happen in the early 1900s, and guess what? It won't happen today, probably, to achieve the full federal incorporation. It's not something that will happen, and that may be a good thing.
Thank you, Sam. So our next panelist is Jim Hart. Jim's also a professor of law here at UCLA. And his teaching and research interests include securities reg and corporate law. Before joining our faculty, Jim was a member of the Brooklyn Law School faculty. He began his career at Wachtell, Lipton, Rosen and Katz, and then served as Assistant Attorney General in the Investor Protection Bureau of the New York State Attorney General's office. Jim's presenting his paper, Delaware and Santa Fe Industries. According to Jim, Delaware may be at a tipping point in its corporate law dominance. The U.S. Supreme Court's decision in Santa Fe protected Delaware's corporate law franchise as long as corporate law grievances sounded in fiduciary duty violations that did not implicate flawed disclosure. But Jim points out as disclosure claims increase, Santa Fe can no longer really be counted on to serve as a bulwark against the federalization of corporate law. But fortunately for Delaware, Jim suggests another potential boundary line that may preserve Delaware's dominance.
Thank you, Iman. My chapter starts 40 or 50 years after Sunghee's chapter, in a sense. It looks at a lot of the early 10b-5 litigation all the way up to Santa Fe Industries versus Green. Arguably the most important case setting forth a line between federal securities law and state corporate law. A Delaware judge once wrote that it abruptly reversed what was a creeping federalization of corporate law. The case very simply held that you can't bring a 10b-5 action alleging just a breach of fiduciary duty. You need something other than that. And so I basically asked a couple of questions in writing this chapter. And the first is, why did minority shareholders think they could win this case? Why did they think they could bring a fiduciary duty claim? And second, it just seems to me that Santa Fe is not as robust anymore. It doesn't do as good of a job of protecting Delaware from federal intervention. Federal litigation has played an increasing role with respect to corporate governance, as we've seen, and so Santa Fe does not seem to be doing as much work as it once did. And I think I discovered that in researching and answering the first question, I was able to answer the second. If you look at most of the early 10b-5 cases, they occur within a very particular context. Minority shareholders who are exploited by controlling shareholders. And Santa Fe essentially helped Delaware reverse federalization with respect to that issue. But as we've seen, the nature of corporate governance problems changed over the last 15 and 20 years outside of that particular context. Santa Fe's principle has become less relevant, and I propose some ideas for thinking about how we can reestablish a boundary between corporate and securities law. So most of these cases, these 10b-5 cases, were in the Second Circuit Court of Appeals, and in some ways the story is about a potential judicial competitor to the Delaware Chancery. That's the Second Circuit Court of Appeals. Without Santa Fe, we might be talking more about the Second Circuit as a leading maker of corporate law than, or as much as the Delaware Chancery, but to the extent that Santa Fe and other events have reduced the use of 10b-5 in this context, the Second Circuit has faded to some extent. So the Santa Fe shareholders, in my view, had two barriers to overcome before they could bring a 10b-5 claim in a freeze-out merger. And the first doctrinal barrier, which was set forth by the Second Circuit, was something called the Birnbaum Doctrine, the Birnbaum Rule, which basically says you need to either purchase or sell a security to have standing to bring suit under Rule 10b-5. And a lot of corporate governance issues don't involve such a purchase or sale. So various plaintiffs would need to overcome that particular barrier. The second barrier was that you needed deception. You needed a material misrepresentation, something that was fraudulent to bring a claim under Rule 10b-5, and that was set forth in a case called O'Neill versus Maytack in the Second Circuit. So the first barrier gave way in a case called Vine versus Beneficial Finance Company. Vine was a freeze-out merger where the minority shareholders wanted to bring suit, and the defendant said, look, you didn't buy or sell a security. You had no power to effectuate this freeze-out merger transaction. You had no power to stop it because you're in the minority. So how can you say you actually purchased or sold securities? The argument to me has a certain resonance to it, right? If you think about a freeze-out transaction, it's not a transaction where a shareholder makes an independent decision whether to buy or sell a stock. It's really the board of directors that makes that decision for the company as a whole. The Second Circuit, though, disagreed, and they said, well, you're not actually buying or selling a security, minority shareholder, but you're being forced to sell. You're forced to sell, and therefore we think that's enough to satisfy the Birnbaum requirement that there be a purchase or sale of securities in connection with a Rule 10b-5 case. In my view, the case is arguably wrongly decided. I think that there's some alternative ways the court could have gone, but at least at this point of the presentation, it suffices to say that if Vine had gone the other way, the minority shareholders in Santa Fe would never have been able to bring their claim under Rule 10b-5. The next major case that enabled the claim in Santa Fe was a case called Schoenbaum. Schoenbaum was a 10b-5 case where the minority shareholders brought suit because the controlling shareholder was able to buy a bunch of company stock at a very significant discount. And so the question in that case was that there was no explicit misrepresentation that was made to the minority shareholders. There was just a transaction that happened. So could you bring a 10b-5 suit in those cases, in that situation where there was not an explicit deception? And the Second Circuit said yes. It created what was later called a theory of new fraud. And the theory was specifically with respect to the context of a controlling shareholder that was self-dealing. And the Second Circuit basically said that in that particular context, we can think of that as being a type of manipulative course of conduct that might fall under Rule 10b-5. So a very dramatic departure from a case like O'Neill, which said that you needed an explicit deception in order to bring a claim under 10b-5. So if you look at the plaintiff's complaint, their arguments in the Second Circuit, in the Southern District of New York, and then the Second Circuit, they rely upon these two precedents in bringing their claim. First, they argue under Vine, they are forced sellers, therefore they can challenge a freeze-out merger, they have standing under the Birnbaum rule. And then secondly, they essentially made a Schoenbaum argument in challenging a freeze-out transaction which they alleged to be at an inadequate price. The Second Circuit actually accepted this argument. The lower court in this case said that the claim could proceed. The Second Circuit said that a claim under Rule 10b-5 in connection with the Delaware short-form merger, that the majority has committed a breach of its fiduciary duty to deal fairly with minority shareholders, states a claim under Rule 10b-5. As we know, the U.S. Supreme Court reversed that decision in its decision in Santa Fe. It said that you cannot solely assert a breach of fiduciary duty claim under Rule 10b-5. Instead, you need some deception, misrepresentation, or non-disclosure in order to proceed. And in doing so, they theorized a little bit about the line between federal securities law and state corporate law. They noted, or they asserted, that securities law is essentially about disclosure, while corporate law is essentially about the internal affairs of the corporation. This disclosure approach, as I've noted in another article, is sort of the most common way of distinguishing between securities and corporate law. This is what Santa Fe stands for, and it is arguably the reason why Delaware was able to rise to prominence in the 1980s, or reaffirm its prominence. It was already prominent in making state corporate law. I wanted to raise, though, some skepticism as to this conventional story, that Santa Fe is what enabled Delaware to become a leader in state corporate law. It seems to me that it was certainly useful for Delaware that you could not assert breach of fiduciary duty claims directly under Rule 10b-5. But at the same time, the court left open the possibility that you could assert such a claim if you allege some deception. In a later case called Goldberg versus Meritor, the Second Circuit seemed to reaffirm the possibility that Schoenbaum claims could still proceed in certain circumstances. And because pretty much every freeze-out merger involves some valuation, it seems to me that you can almost always make an argument that there is some deception in the freeze-out merger itself. So Santa Fe didn't actually preclude the use of 10b-5 to challenge freeze-out transactions. To me, Santa Fe, while important, did not entirely preclude federal claims in this area. What happened, in my view, was simply that Delaware got a little bit lucky. Got a little bit lucky because of the Weinberger case, and that particular case just happened to come up 4 or 5 years after Santa Fe Industries. Weinberger, as you know, is a case involving a freeze-out transaction, and it was just the perfect case. It was just the perfect case to illustrate some of the dangers of these particular transactions. As you may recall, in that case, the parent company's representatives sat on the board of directors of a subsidiary. The parent company wanted to buy out the subsidiary in a freeze-out transaction. And these employees who were board members of the subsidiary, they write this report saying that we can do the transaction at $24 a share and it would be a good deal for us. When in fact, and then eventually they actually negotiated a deal for $21. They never disclosed the report, right? They didn't disclose the report even though they were fiduciaries to the subsidiary. So the Delaware court obviously was able to find a breach of fiduciary duty argument in this case, and they set forth a 2-part test that requires Delaware courts in scrutinizing freeze-out to look at the fairness of both the process and the price by which we get to the freeze-out merger. Because this particular case just involved the perfect facts, the unlikely situation where you had this conflict of interest, the unlikely situation where you had a smoking gun, where you could establish a clear disclosure violation that was a breach of fiduciary duty, the Weinberger standard rose to prominence. And I think in effect, plaintiffs no longer had a good reason to bring 10b-5 claims, because they could always proceed under Weinberger, and they had an indication that at least in some cases Delaware courts might be potentially open to these sorts of transactions. After Weinberger, you see a real shift in the fortunes of 10b-5 versus Delaware. 10b-5 cases became dominated by what many would have argued were meritless strike suits in fraud on the market class actions, while Delaware decided important case after important case involving cases involving breach of fiduciary duty claims. This has changed, though, more recently. I think the situations have been reversed. In the early 2000s, as we know, we had a wave of corporate accounting frauds, the collapse of Enron and WorldCom. And the primary issue in corporate governance, at least for a time, became essentially the duty to monitor, right? The duty to monitor a company for severe frauds. That was the compelling corporate governance issue we saw beginning in the 2000s. And in that particular context, there's a good argument that the federal government has a comparative advantage. Internal controls, requiring further assessment of those internal controls. These are sort of ex-ante ways the federal securities laws essentially police this issue of monitoring. 10b-5 class actions became more meritorious. They began to result in high-profile settlements, and so we see them very visibly regulating this issue of monitoring the company for severe frauds. Delaware didn't give up. It tried to respond, but I think that There's a good argument that its response has not been particularly effective relative to federal intervention. Delaware tried to highlight its duty to monitor in Stone versus Ritter, the so-called care mark duties. But those duties are fairly weak. You need really a almost complete collapse or absence of internal controls in order for there to be liability under that standard. We see Delaware highlighting the duty to disclose, as Professor Thompson has noted in an article in 2007. There were a number of cases re-emphasizing disclosure, and I think one way of reading that move was a response to federal intervention, trying to be a little bit tougher and carving out a distinct role. As we know from the work of others in this room, that emphasis on disclosure has arguably been a disaster. Right? Virtually every M&A transaction is now challenged on disclosure grounds. And so Delaware's response has not been all that effective. So where does that leave us now? Where does that leave us now? Does this mean that Delaware is forever going to take a secondary role relative to the federal government? I'm not so sure. I don't know. I think to some extent, one way Delaware could push back is by trying to better articulate the distinction between corporate law and securities law. In a prior article that just came out this month, I make an argument that the Birnbaum Doctrine might actually be a better way of distinguishing between corporate and securities law. That the idea that securities law focuses on the interests of trading investors, while corporate law focuses on the interests of investors while they're holding the shares, might be a better way of distinguishing between securities and corporate law than the disclosure principle that comes out of Santa Fe Industries versus Green. It's unclear, though, that just thinking about the issue will reestablish Delaware's prominence. I'm not sure that even if you have a good argument for drawing the line between federal and securities law, or federal securities law and state corporate law in a certain way, that will make a real difference in restraining federal policymakers. But there's hope, right? There's hope, I guess. One of the one of the few benefits, perhaps, of the Trump administration is that you will see a rollback of some of these federal corporate law provisions, and I think that, to some extent, that's a very good thing for Delaware, and that might be a good thing for the way we make corporate law in this country. So I think the final point I want to make is, perhaps the lesson of all this, the lesson of my chapter, is that when you think about the balance between federal and state governance in this issue, it really just depends on the context, right? Sometimes the corporate governance issue of the day is something that is very well suited to what Delaware does. Sometimes it's not. I think Delaware won this early competition because if you think about the rights of minority shareholders versus the controlling shareholder, that to me is fundamentally a corporate law issue, right? Protecting the minority shareholder from exploitation by the dominant shareholder, that is squarely within the purpose of corporate law. The federal government lost that, I think, because it's quite obvious that that is the core essence of that particular issue. It's possible the situation will change in the future, and perhaps Delaware will reestablish its dominance. Thanks.
I'm going to go on. So our final panelist for the topic of Milken versus Washington is Bob Thompson. And Bob is a member of the Georgetown Law Faculty. In addition to his academic articles, Bob is an author of casebooks on corporations and on mergers, and treatises on post-corporations and the oppression of minority shareholders and LLC members. Bob has also been the editor of the Corporate Practice Commentator, served as an advisor for the American Law Institute's Restatement Third Agency, and chaired 2 sections of the AALS. Now, Bob's paper is titled Delaware's Dominance, a Peculiar Illustration of America's Federalism. Bob wants us to think about the question of corporate federalism not so much as an on-off one, in which there's a clean division of labor between the feds and the state on corporate law, Rather, he argues that the contemporary landscape of corporate federalism is more nuanced and dynamic, that it's an arrangement of what he calls cooperative federalism. And my question to him, as he is about to present, is whether this is the new normal, and is it potentially more efficient than classical federalism?
And I have a few slides if I can find how to. Great. Thank you. My approach is to look at this Delaware, Washington, from a federalism standpoint, as my co-panelists have done, but to push harder on federalism. I point to three dimensions that are going on at the same time. The first is a race between the states as opposed to state versus federal. Now, the title to the conference was deliciously ambiguous as to whether or not who's going to dethrone them. Is it Nevada, or is it the feds, or is it both, or someone else? But I think they're separate dimensions. So talk about the race between the states. Secondly, there's an ongoing philosophical debate about, do we rely on markets, do we rely on private ordering, or do we rely on regulation? And this underlays all of the debate about this. And third, there's this direct state federalism. As Alon's already said, I have a different view of federalism based upon areas outside the room, those outside the silo. But my context is to go back further than Sun did, to talk about pre-21st century corporate law, and particularly a point of inflection that comes just before her period. The point that I would say is that none of the three dimensions I've told you, the race among the states, the regulatory versus private ordering, or state versus federal, was there for the whole first half of American history. We had corporate law for all the first half of American history, but it didn't have any of the current dimensions. And there were different reasons for that. The questionable constitutional authority over regulating foreign corporations, outstate corporations, limited competition. Government regulation was actually, of corporations was actually common during the 19th century. We didn't get this split of deregulation of private ordering until later. There were vibrant doctrines of quo warranto and ultra vires. I love the fact that this week, maybe if you're not in Washington, you don't appreciate the emoluments clause and the leases of Trump. Quo warranto is back, folks, and only us have ever dealt with it. So you can do op-eds on quo warranto. Since corporate law was so unusual, since it was almost always at state level, there was almost no federalism for the first half. Then what happened? And there's a point of inflection, and this point comes from Wiley Rutledge. You know Wiley Rutledge? The only that I know of, the only corporate law professor ever to be on the U.S. Supreme Court, part of the New Deal, part of Roosevelt's New Deal. He wrote an article in his corporate law professor days about, in the 1930s, about how corporate law changed in the 1890s. 1882 to 1892 was this point of inflection, and that to me is crucial to getting to Sun's chapter. Until then, we had the history I just described to you, and the 3 points weren't there. Then what happened? New Jersey in 1880, 1889, New Jersey passed laws that permitted corporations to own stock in other corporations. This is what dealt with the Standard Oil problem of going across state lines. This is what made the trust possible, and when the trust got canned by, it made corporate law succeeding trust law. Secondly, limiting or regulating foreign corporations receded during this period. Third, the most important, you probably know about the 1896 New Jersey statute, what I would call the laissez-faire corporations code. Delaware followed right after it, 1899, the same stuff. It did all sorts of deferring to private ordering. It removed all the limits of the 19th century on size, on purpose, on duration that had been part of corporate law from the beginning. It removed them. It authorized doing business in other states, dealing effectively with the out-of-state business. It provided for mergers, which had not happened before, and consolidations, and it increased control by boards of managers. Up until then, the general meeting of shareholders had still been important. This disappears in 1896. Joel Seligman called this a revolution of all corporations. He captured it exactly right. He turned corporate law inside out. Now, what is less understood, it seems to me, that I would push to you, is that this was part of a larger economic social change that was going on in the late 19th century. And what surprised me in reading about this era is that how common it was to explain this change, that the emergence of large-scale corporate concentration is the key word, was seen as necessary, if not inevitable. This is what Riley Rutledge said. This is what Morton Horowitz said. These were not people that believed in, that had something in for the laissez-faire approach to regulation. And they saw this as responding inevitably to what was going on in the world. And that's when corporate law changed. And ever since, state corporate law has been pretty fixed about saying we're going to prefer private ordering and not regulate. Now, this regulatory impulse did not go away. Where did it go? It went straight to federal law. Not quite in the way that, not quite in the example that Sue was talking about, but in the antitrust law writ large, including the Sherman Act and then the Clayton Act after her period. In employment rules of railroads, regulating what railroads could do, and the FTC after her period. In limits on corporate political contributions, which date from this era. And into the later era, securities laws in 1933 and thereafter picked up this impulse to regulate. But what we had was this split between a state law approach to prefer private ordering, enable private ordering, and a federal law approach that said, we're going to slap you down with regulation when it occurs. So what happened is, after this point, for the first time, the three dimensions of who makes corporate law were in full view. States could compete with each other. New Jersey was competing with the big city across the river, but it didn't spread to everybody else. There was a federal law presence for the first time, and that led to federalism, but more importantly, what we saw was this split between deference to private ordering and mandatory regulation. Riley Rutledge said this reversed the historic policy of the states, and it placed state policy fundamentally in opposition to federal government, and that's why we have federalism that we're talking about. Now, so I want to talk a little bit more about federalism, and what I want to suggest to you here is that all of us are too much locked into federalism of the 1960s and 70s. That means we're locked into Bill Carey and to the race to the bottom, the race to the top, and Ralph Winter and Roberto Romano. We're still stuck in that. We're stuck in what Jim talked about is a line. We're figuring out which side of the line we are. But the federal government did not supplant state corporations for the reason that Sue was talked about. It just added mandatory rules in particular places, often to empower shareholders. I think that Rogue has an important addition. He talked about how the federal presence, as it had been enacted from 1890 until the 60s, meant that corporate law was at the sufferance of the federal government, and that impacts what we see in terms of federal law. So that's the history. What I want to suggest to you as something different is what I see as 21st century corporate federalism. And what I want to suggest to you is that it's not an on-off switch about who has the power. It's not the state law has the power, federal law has the power. That's how I thought about it for most of my years in teaching. It is a much more interactive, much more shared power. And that's consistent with what's going on outside of corporate law that I'll talk about in just a moment. I want to give you 4 examples. The first is shareholder voting and misrepresentations. What I find interesting about the history is that the feds start with Borak in the 60s. We see a strong federal move into federalizing shareholder voting and protecting misrepresentation shareholder voting from 1489. And for a decade, until, and I would date it, not Santa Fe, but in until the day in 1972, one day in January, in which Lewis Powell and William Rehnquist show up on the same day to work at the Supreme Court. Ever since then, we saw this change. What's happened? 1489 cases have pretty much disappeared. Does anyone still teach 1489 cases in your corporations course? It was why are you doing that? It's gone. What's happened is that
They're actually back.
It's coming back.
So Jill and I have an article published in Statistics that the litigation's migrated in the wake of Trulia to federal court.
a fair point, and then the question will stand. We can talk about that, but I think there's another side to that, which is that state law. You can have your say. State law has supplanted it, and it's really because of, and the best example that I see is TOPS. That TOPS lets litigants do everything they want to do in federal court, in state court, plus they get red line, plus they get whatever else, and that other than the procedural point, which is what I would, but that's getting to, this is a dominant thing for states. What's amazing is that how do the states do this? They borrowed lock, stock, and barrel from the federal courts. State law developed their rule of disclosure by saying, the feds have done a lot of work, we're going to go pull it in and let them do all the work, and then we'll use it to rule this breach of fiduciary duty. There's this integration of state and federal law. What is interesting is, this is opposite than what's happened with 10b-5. In 10b-5, there's no state claim. And I think it's because of Lowell versus Brincat. You can debate where that comes from, but the result is that the state law presence in buying and selling, protecting shareholders in buying and selling, is much less than state law protection in voting. And so but the overall point is integration of state and federal law in terms of providing remedies. Second example, how do shareholders vote? You would think that'd be a state law concern. The main federal law rule, it turns out, is withhold. You can withhold your vote. Now, that's an empty gesture. I mean, I don't know the story about why they first did it, but it didn't ever do much. What happens? Only when a change in the bylaws in Delaware occurs, that if you combine, and it's the combination of combining a bylaw, majority vote bylaw, with the withholding power from the federal government, with the market power of institutional shareholders in the last 10 years, that this becomes very powerful. It was not a line, it was not on and off, it was not federal government doing, it was not state government doing, it was private ordering, mixing and pulling private and state, and that's what corporate law is today, this interaction. Two more examples, say on pay. Say on pay has a federal hook, but it is, as you know, it's a preparatory federal hook. It doesn't matter, it doesn't count, it doesn't really matter as a PowerPoint. But what happens? It gets combined with the state law, a different state law power to the core state law power to remove directors. And you have to make it up. Even that doesn't work until you combine it with the institutional shareholder willingness to combine the two. And so what we have is corporate law that is inherently this mixture of really three things: federal law, state law, and the market power of the institutional investors is different than it was for most of our lives. Last example, removing staggered boards. Again, you see the use of a precatory, this time 14A8, to prompt the board to amend the articles. It only works if the institutional shareholders are willing to use their state law power to remove directors in connection with the 14A8. And they don't do it all the time, they just do it some of the time, and so when will they use their market power? Again, corporate law is not an on-off federal law, state law. It is the combination of federal law, state law, and market power. And I think this is what corporate law is today. Now, I then want to pair those examples, with a bit of theory. And the theory comes from outside of our silo, outside of what all of us have thought about in terms of federalism in our time in the academy. It comes from energy law. It comes from environmental law, it comes from education law, it comes from lots of different areas our colleagues are working on federalism. The move that's described there is the traditional focus on dual federalism, and if you've done any regional federalism, you'll probably remember that it talks about the state realm and the federal realm, and each government has exclusive control over non-overlapping regions of authority, and then the courts police that line, and that's the dual federalism. The Supreme Court's New Deal cases, the acceptance of a broader federal power under the Interstate Commerce Clause that we all know from the 30s, blurs that line. But what's interesting is dual federalism, even with that great blurring, dual federalism still persists. Robert Shapiro has a couple of good articles on that score. And I think if you look at a number of our important corporate law cases, they reflect this formal dual federalism of the line. Business Roundtable does that. I think, frankly, Santa Fe does that. Not exactly the part that Jim cited, but the part when it says we are reluctant to federalize the part of that is state law, the state law realm. I think it's this dual federalism point. What I find powerful is that outside of our silo, that's not how federalism is being discussed. Federalism is being discussed, as Amit said, in this much more cooperative way. Now, what does cooperative federalism mean? You can go do the reading, but I'll give you one quote. It is concurrent regulation, as of the examples I just described. It's an assertion, theoretical assertion, that's supreme, that's superior to what could be achieved by independent activity of either the state or the federal government. And you see things like, what are the benefits of that? Plurality, dialogue, positive redundancy, greater regulatory competition, policy innovation, resistance to monopolies, and group capture. So the sense is, ought we be explaining more of what we see as part of interactive federalism? Just a little more explanation. If you look at from outside of our silos, there are elements. This part comes from David Spence that talks about what ought you to pursue if you pursue this kind of approach. Look for the lowest element of government that can encompass both the costs and the benefits of the regulated activity, and that's who should regulate. Look at whether or not the government is captive or unwilling to regulate. Is there a need for a uniform standard? Is there an important national interest? This is a way to decide how you allocate. It's interesting that most of these other areas don't talk about corporate law. Our part doesn't fit quite the same way to it. For example, the internal affairs doctrine is very important to trying to fit our federalism to their federalism. I think it limits number 3, and it reduces the effect of number 4. One of the key things in environmental and energy is there a spillover across state lines, which is a common externalization problem. And I think internal affairs actually can limit that. And so I think but the one thing that it can't do, the race to the bottom, the unwillingness or being captured is still a problem that overlaps both. And so I think that remains the focus. What I want to suggest to conclude with this slide is, okay, if you buy into federalism as I've widened the description, what does that tell us about will Delaware be dethroned? And what I would say is, first, federalism, however you define it, federalism significantly affects the race between the states. I mean, you clearly can't not do it. What comes clear is that Delaware has good reason to care about its position. So you know about the budget that comes from that. That's a big incentive. But the other thing I would say is it also affects the economy of the state. We're delighted to have a distinguished member of the Delaware judiciary here. The other guys in suits, except for this guy, are from the Delaware bar. This is important about why Delaware is going to win, because that benefits. Have you ever been to a conference with a Nevada judge? or a North Dakota judge. You don't see lawyers from those states. In no other state can you be a judge and be able to travel to Los Angeles on a beautiful spring poetry.
Former judges.
Yeah, former judges. Yeah. This is something that, I mean, Nevada with its casinos, corporate revenue will never be as important to Nevada as it is to Delaware. Delaware has great incentives to get it right. Secondly, Delaware, you can be challenged in two directions. You can either be challenged by a co-shareholder state, think North Dakota, and that's not going to happen. Why? Well, first off, they're already competing with the federal government that's doing its regulatory deal, and you got to do it better than them or different than them. Why would someone want to incorporate? And the answer is, probably won't. Hasn't happened, won't happen. Okay, what about the other direction? Can you be challenged from the pro-management side? Well, that too is cabined by the feds. That if you go too far, the feds have shown over and over and over again, they'll step in. Even maybe it'll be different in the current administration, but the pattern probably won't change. They'll step in. And so you have to worry about competing with the feds, and it just won't work. Nevada's the one that's done it, and was McCall, is she coming? I don't see. But Nevada has the
A lot of
best.
the flights were delayed, so.
Yeah, so more flights delayed, yeah. We were dealing out on the flight last night, we're glad to be here. The LDAR piece that I don't know if you've seen, shows that data shows that, as others, the studies have shown, that Nevada has made inroads with smaller corporations and those with smaller institutional investors. But what this study shows, different than others, is that if Delaware were to change its model, it would lose like 13% of its market share. I think there's some truth to that. So I think what we have, if you look at if you game it, what we have is that the federalism part, the distinction between Delaware state law everywhere emphasizing private ordering and enabling private ordering, and the federal government emphasizing regulation. This pattern that's been since 1890 means that there's a Delaware lock-in, and consistent with Roe, that we're not going to see a change as long as we have this federalism pattern, and we're going to have this federalism pattern until we have a disruptor or whatever. And I think the odds are we can come back in 10 or 20 years and have the same discussion.
Thank you. Okay, thank you, everybody. So I'm going to start us off with a general question for our panel, just to get things rolling. And then I'll open up to the floor to ask either the entire panel question or individuals. I mean, one question that I had that I'm genuinely interested in for the panel, maybe I'll ask Bob to start, is that, and the question is Delaware so dominant? I know you mentioned that its dominance is contingent, that it could lose market share, but is Delaware so dominant that the federal government's really a necessary player in corporate law in order to really provide a credible alternative to Delaware? Or do you think that the states are genuine alternatives?
I think the feds are a necessary player, and the states, as we now do, can't play the role. And why? Because no one else has the incentives that Delaware has. The budgetary incentive is crucial. I mean, these guys in the front row pay less taxes because Delaware has, and that won't happen in Nevada, or certainly not in California. It won't happen if the federal government, this is a drop in the bucket for the federal budget. And the incentives of getting ahead of the world, for lack of a better term, it won't be replicated in other states. And so I think Delaware, I liked your point about the Second Circuit as an alternative. It could have happened, but it won't happen now. And so I think there is not another player, and the federal government plays an important role as the counterbalance, and I think that keeps the system more stable.
That's a good question. I wonder, though, if the federal intervention has become more greater than optimal at this point in time. I wonder if, I agree with Bob's point that we are living in this world of interactive federalism. But to some extent, that still requires us to be asked the question, which is what's Delaware's role within the system? If we don't articulate a very good role, then the federal government has so much power, so much momentum that it will squeeze out Delaware to some extent. So I actually don't think the issue is whether or not we need a check on Delaware, at least in this day and age. I think the real issue is whether or not federal intervention has grown too large in a sense. So I think that that's the question I think I'm a little bit more concerned about today.
So I like the term cooperative federalism and substantial agreement with that. I guess I'm a little bit less worried about the threat of federal intervention, even though it seems like they've been really active in the past decade. It's because we had pretty dramatic focusing events, right? Huge scandals, Enron, WorldCom, the financial crisis. Maybe the problem is, for some reason, we're having these financial scandals. But it takes a lot, in my view, for the federal government to intervene. And it does intervene regularly, but it's about once a decade, right? And that's not a tremendous amount. So I still think Delaware has a lot of leeway, has a lot of power, but it is shaped. It's incentives. The judges' incentives, I think, and obviously there's judges, correct me if they think I'm wrong, they're shaped by the looming threat of federal intervention. Mark Rowe says that Delaware is incentivized to forge a status quo-oriented middle path between shareholders and managers. And I think that's probably largely correct, and that will probably keep Delaware's dominance. I don't think other states will present a competition for Delaware. I think it really is Delaware is where it's at, and the only feasible alternative is the feds. But Delaware judges are not, they're not stupid. They're not going to enact radical law that overwhelmingly favors either shareholders or managers, or hurts, or more importantly, hurts other interests. Although the way Rowe characterized it, they're really only concerned about managers and shareholders, whereas the feds are concerned about a broader array of interests. Economic policy wonks, environmentalism, populism. And populism is a force, and it's increasingly a force now. So that would be interesting. Will the federal government, under the Trump administration, have the populist concerns pressure Congress to become more active in terms of constraining state law? That's a question I'd like to know.
I was talking with Keith Bishop about Nevada law. Do you agree that is there a credible threat from the states to the Delaware courts?
Well, I first of all, having grown up in Las Vegas and spent my life answering the question or the statement, I didn't know people actually lived in Las Vegas, but they do. The name of the state is Nevada, not Nevada. So
That's what I said.
in Nevada, I do think Nevada, I mean, we could debate about how successful it is, but I don't think there's much we can debate about whether Nevada is trying. I mean, that's reflected in the legislative history and in the legislation that Nevada has passed since the early 1990s. They seem to take everything that Delaware does and take it one step further. And they've been doing it very consistently for more than 20 years. So they're trying. And in an odd way, I think Nevada is like Delaware in that it has a relatively small population, not as many diverse interests as California does in terms of geography and all the different constituencies, which allows the legislature to be more focused on a narrow industrial base and the possibility of providing revenue from the corporate charter market. So they clearly do better than California, and they are, by the data that I see, they're the second, they're a long way behind Delaware, but the second most popular state in the country for public company incorporation.
Okay, well, let's get some other questions on the table. Bill?
I was interested in hearing the sequence from early times through Bob's recounting of recent years. I think it reveals one thing, that early proposals for federal corporation law and big changes are probably doomed to failure with too many conflicts built into the interest groups. And so what we've seen more recently, and Bob's account I think is where you can see this most dramatically, is politicians like to say, don't ever let a crisis go to waste. And so every time there's any kind of a crisis, the federal government's there with some new nibble at state autonomy in these areas. And if that continues, I hold out a lot of hope for Delaware's dominance in the long run.
I guess I believe in the inherent value of private ordering. That is a natural contrary barrier to that. And yeah, I agree with Bill that there's nibbling. But it's nibbling. The question, I think, I'm on a panel with UCLA colleagues, but I'll cite one more that's not on at the table. Stuart Danner has talked about why the securities law changed. He looks back over 400 years, and he says it's because of one reason only. It's because of scandal. It's because of crisis. And he documents not just the U.S., but for other countries as well over 400 years. And you see it in 1929. You see it in 2001 with the dot-com crisis. You see it in 2008 after the financial crisis. And corporate law hasn't had that same pattern. So I think Stuart's got it right that crisis and panic and crashes is what leads to and if you look at even at the 21st century changes, Sarbanes-Oxley and Dodd-Frank, corporate law was an afterthought. The core of corporate law, at least the things that I talked about and Jim talked about, are an afterthought that just got in the corollary to your point about a crisis, this terrible thing to waste, is that we end up with Christmas tree bills when the panic when it occurs, and that's where the corporate law stuff just more recently got thrown in. So I'm actually more optimistic about Delaware.
Good.
And I just want to add that these scandals and focusing events are obviously very important for major federal government intervention. But as we saw in the panic of 1907, which I do talk about briefly, there does have to be a plausible link with corporate governments. And that link wasn't there for that particular panic. Ultimately, Congress bought the explanation that it was an inelastic money supply that caused the panic. So they couldn't really use that focusing event or scandal to intervene in a big way in terms of federal corporation. They did pass an act, but it was a pretty narrow act. So there does need to be some nexus with corporate misbehavior for the feds to intervene that way. There is some limitation.
Gil, do you want to weigh in, or you?
Yeah, just a couple of thoughts. I was struck by your statement that back in 1908, what both constituents were looking for labor management was certainty and uniformity. And back then, we hadn't developed the body of jurisprudence in the states, Delaware in particular, but not at that point in New Jersey, to know that the states were capable of doing it. If you look at the same picture now, and then you ask yourself, what would our corporate law look like if these nuanced questions of fiduciary duty and the like were being decided by hundreds of federal judges, many of whom, unlike the Delaware Court of Chancery or Supreme Court, either didn't have the background, or in Delaware, you could be a family court judge, you become a corporate lawyer pretty quickly if you sit on our Court of Chancery and you see these cases over and over and over and you talk to your colleagues. But that wouldn't happen in the federal system. So I have some faith that if this ever came up, our congressional leaders will look at this and say, we have a lot of lobbying, by the way, from all constituencies, I think both stockholders and corporations, to make any move toward federal incorporation is inconceivable in this time. Second thing about Nevada,
You gotta say it right, Gil.
Nevada.
Right, we don't spend all the debate.
Yeah, Nevada.
We know how to answer that.
I can just give you an inside picture, having been involved in a very significant way in a lot of legislation in Delaware. I think our view is, first place, we're not going to race to the bottom, for reasons that will be discussed later in this. But also, I think for major corporations, Nevada still carries a little bit of a gambling image. And I don't think that's the image that if you go out to your investors that you necessarily, in a public company, that you necessarily want to portray. So I think that's a fact, and I've thought that for a long time. And finally, there's one other thing about federal intervention. You're absolutely right. We've had, in my tenure, more recently at least, two, Sarbanes-Oxley and Dodd-Frank. And you knew then that the crisis was going to get this to be looked at and you know, even fought back where we could to have them not overreach. But you also knew that it was highly unlikely that the federal government was going to do what Delaware and other states do all the time, and that is fine-tune their law to respond to changes in the business and corporate community. And it's just a fact of life. It is crisis-oriented, and the idea that you're going to get before Congress on a sort of revision of any of these sort of corporate intrusive regulations it's more like it's frozen in time. Now we may, in this administration, see actually some effort to look at it again, but that's almost just a coin flip. If the election had gone the other way, it would probably have been another 8 years before anybody could look at these things, and we still don't know when they look at them if they're going to do anything about them.
Jill has a question, but Keith, did you want to have a moment?
Respond on the Nevada thing.
Well, I agree. I think that there is, a question of, does Nevada have that aroma of Bugsy Siegel and gambling? And I think there is no question that it does. It hasn't stopped some major non-union corporations that are headquartered outside of Nevada to incorporate in Nevada. It probably has proved an attraction. I just read the other day about, I guess, the burgeoning marijuana industry is viewing Nevada as a friendly state to incorporate in. And maybe they like it.
There's a good combination, gambling and marijuana. For more reason.
You'll have a football team.
Yeah. So, there are a number of factors, and it just remains to be seen.
Can I ask a quick follow-up? Do you have data on what percentage of its revenue Nevada gets from corporate chartering? Is it remotely close to what in Delaware it's historically been, 20% in that range?
I don't have it off the top of my head, but when you think about it, they did raise a couple of years ago their franchise fees significantly. But as Delaware knows, there's all the collateral, the lawyers that make money and pay taxes, although Nevada doesn't have an income tax. They pay other taxes in the state of Nevada. There's hundreds of incorporation, resident agent services that generate revenue for the state of Nevada. So there's an obvious incentive. I don't have a number off the top of my head.
Jill?
So, I have a question for Jim, and I have a question for Bob, but I'll defer the question for Bob. And if there's a lull, we can always get back to it. But the question that I have for Jim, I think it's really interesting, your analysis of the role that Santa Fe played, and Stephen and Sean and I did this in a slightly different context in the merger cases. But I wonder if you could tell a different story about what's going on, and that is that the court in Santa Fe basically got it right. If you're going to challenge a merger, if you're going to challenge a corporate transaction, The challenge should be that the shareholders have been lied to, and otherwise, we should kind of trust to the internal dynamic, the private ordering, the shareholder voting, right? You look at the very recent Delaware cases, right, like Corwin and MFW, and what the Delaware courts are doing is essentially getting to the same place that the federal court got to years earlier in Santa Fe. So it isn't really a story of, or maybe it's just, evasion. Delaware maybe loses its way for a little while, but, it's not kind of these two different approaches. There is a right answer, and, Delaware's just a little slow to get there.
Well, what do you mean by the right answer for Delaware? Is it that they should be policing disclosure to some extent as well, or? Well,
that's not what Trulia says, right? Or Trulia or Corwin or Volcano or any of these.
Delaware's kind of withdrawn, and now we're back to sort of that balance. I think that's right, but I think what Steve was saying about the rise of 14A9 cases, though, that might be sort of another example where we have disclosure cases that are in federal court to some extent, and so. To some extent, I'm not sure if disclosure really separates the two.
Well, it's not that. It's that, you can't, disclosure is the right way of restraining misconduct, but it has to be a meaningful disclosure issue, right? The common ground between Trulia and Santa Fe against Green is, right, it's not any old disclosure issue. It's one that has to amount to fraud, which is what Chancellor Bouchard says in Trulia, We're not going to reject all disclosure settlements, but it has to be an issue that's plainly material.
I think that's right. I don't think we disagree in that sense. I mean, I guess my the main point I was really making was that, disclosure by itself doesn't seem to separate federal and securities law in a sense. And so that, we see that, if corporate law is deciding cases on disclosure issues, that it obviously there's some overlap there in terms of the two regulatory regimes. And I think part of it is also about, and I think the point I made was that I don't think Santa Fe actually cut off those cases, that you still could bring those cases under 10b-5, but it was really just a happenstance that Weinberger just decided, in a really great case, or it was a really great set of facts, and it just dominated the freeze-out context for some time. And so I don't think we disagree in a sense in terms of sort of the role of disclosure, but I can talk more with you about it later.
Just a few observations. One thing I think folks from outside our state think understandably when you think about all the revenue that we get from franchise taxes is that, okay, this state must be sort of swimming in money. Don't ask me why it's not true, but it's not true. And I think that's, we have a, what is it, $300 million deficit. So now how do we do that, given that we get money from all these corporations around the country and world? I don't know. But so I think that speaks to me to the incentive of Delaware to keep its franchise revenue, because if we didn't have it, I mean, it would be a catastrophe. We're already in bad shape. Secondly, I think a point that is a very, non-academic, but very much a real-world point is the inertia that's out there. If you think about major public companies and what it would take for them to go to another state, it's very difficult. And you can't just sort of have a board meeting, or you don't just have a board meeting and say, let's look at the Nevada statute and some of the decisions, and that looks pretty good, maybe we should change it. It just doesn't happen because it's far too difficult. So I think inertia is very important. For there to be a major seismic shift, I think it will take generations of new companies being formed, going somewhere else. So I don't think there's anything that will...
You're talking about reincorporation as opposed to...
Reincorporation and incorporating new entities that then become public. I think it just takes time because there's great inertia. Another thing that to me is a very real-world factor is, I'm kind of in the trenches kind of factor. It's not intellectual, but it's very real. I defend corporations and officers in litigation, and when you speak to and certainly in the last 10 years when we've had all the multi-forum litigation. Whatever else you say about the Delaware judiciary and the state of the law, and some very big victories have been won by plaintiffs in Delaware in the last 10 years. When you talk to directors and their non-Delaware counsel about would you rather be in state X than in the Court of Chancery, the answer is almost inevitably no, unless they have a very bad case. And they think that, well, maybe if I'm in some other case, I'm in Missouri, no offense to Missouri, maybe we can get some judge to buy this, but I'm pretty sure we're not going to get a chancellor to buy it. And so I think that that is another factor that will keep corporations in Delaware, because they do take comfort from the judiciary. And then the final thing I would say is people rightly comment upon our system where we have the corporate counsel that suggests changes to legislation comprised of attorneys, corporate attorneys, both plaintiffs and defense attorneys. And people look at it and say, well, that they have the ability to structure the law so that it favors the bar. I think that's a very fair criticism. That said, and this really echoes something that Gil said, it's also a great advantage that we have really smart, experienced people across sort of different areas of our practice debating how we should fine-tune our statute. Our legislature in Delaware comprised of very good people, but maybe 2 or 3 lawyers? Three. And good people, but, you know, retired state policemen and hardware store owners and, you know, folks like that. And I view it as a very positive thing compared to other states and the federal system that we are able to, after lots of negotiation, change our statute in a way that makes it better.
Jim?
What I would say as a practicing lawyer in the field of executive compensation is I don't see the federal government, the Congress, being able to enact laws after thoughtful consideration. What we've seen with Dodd-Frank, Sarbanes-Oxley is just a crisis, and if one party's in power enough to jam something through, then something happens. Things are poorly drafted, poorly conceived, left to the agencies to try to figure out, burden the SEC, try to figure out what the hell the CEO pay ratio rules work and how should they be implemented, things that maybe the SEC should not be asked to do. And I just don't think that the federal government, unless things change very dramatically, they're going to be less polarized at it, enough to do what maybe happens when you sit down in Delaware and think about, over a period of years, what should happen to a law. Used to be, when ERISA was enacted, the Congress actually studied what had to be done in the area. And they did it for 3 or 4 years, and they put together a law that was comprehensive, that they understood. These days, I hate to say it, but the senators and the congressmen don't seem to understand what they passed. When they were asked, when they were in Italy on vacation, was SOX 402 intended to apply to split dollar life insurance? And the senator says, of course it was. I don't know that they ever thought about that. So I just don't hold a lot of hope for what the feds could ever do to give us a rational corporate law.
But don't forget that Delaware doesn't have an SEC. Delaware statute is not a regulatory statute. It's a governance statute. It's a private ordering statute. And so the question is, do you need something besides that? And our history since 1890 shows we need regulation. And executive comp may not lend itself to being solved by fiduciary duty and litigation. It may need there's not a prosecutor in Delaware. And so I think the interactive part actually brings strengths in 2 directions, that Delaware has strengths that the feds don't have. There's no judiciary that can do. I mean, you can't have a corporate case heard in district courts around the country. You can't have it in court of appeals around the country. Delaware's judiciary remains an unduplicated benefit. But the other side is that Delaware can't do it without the regulation and the prosecution of public prosecution, leave out private litigation. And so And so I think we're actually going to have this federal system because of that complementary benefit.
Yeah, I just want to add, I think Jim makes a great point, Jim Burrell. But I also think, and this is sort of beyond the topic of today, that one of the reasons why members of Congress don't seem to know what's going on is because they're spending the entire time campaigning, right? They have 2-year terms in the House. That's insane. So I personally know that they actually are campaigning full-time. It's a full-time job, and until we change our Constitution to change that or reform campaign finance, that's going to continue. I also want to add some comments to Gregory's comments, which I thought were very interesting. So Gregory talked about inertia. I would also add, and this is how I guess academics would describe it, network effects, right? There are enormous network effects that Delaware has because it is already the 800-pound gorilla. It has won the state-to-state corporate charter competition. So it definitely has a competitive advantage over upstarts like Nevada. Another thing that Delaware has that a lot of states do not have is predictability. I remember as an associate researching some issue in California corporate laws, the threshold amount of shares you need, percent of shares you need to be deemed a controlling shareholder, and I found almost nothing. By contrast, there was more law on that in Delaware. And it's helpful to have the case law there. The long history and the volume of case law in Delaware makes it a good choice for lawyers to recommend to their clients. But I do have a question that I would like to pose to the practitioners and perhaps the judges. So one thing that Mark Rowe talks about in describing the incentives of the Delaware courts is that Delaware is incentivized to forge this middle ground between shareholders and managers who are the constituents who get to play in Delaware. And he seems to suggest that, well, he does say that Delaware can't go too much in favor of managers, can't pander to managerial interests too much, otherwise shareholders will not only choose to, basically shareholders will cause a reincorporation out of Delaware. And I guess I wanted to pose a question, because this is something I just simply don't know. How likely is that? Are there a lot or any reincorporations out of Delaware caused by shareholders?
The board would have to go along with it, and so, I mean, you could get tremendous institutional pressure, but I'm not aware of that being a significant.
So I have a paper on this. I mean, so basically we look at 50 years of this, and you can get maybe 20 or 30 reincorporations total every year in the public markets, and it balances out between Delaware and outside. It's in the JFE, the 50 years of corporate governance.
What's the impetus for reincorporation?
Who knows? I mean, they're mostly small companies.
They're both into Delaware.
And out. I think there's more into Delaware than out, but they're mostly small companies. There's some into Delaware, into Nevada, whatever you call it, also. But it's very small. I mean, you know, look, I mean, Wachtell's going around saying if Facebook loses their Class C vote, they'll drop a consent and leave Delaware, which would be awesome. But, you know, you don't really see anything if you look at the data. I agree with you.
Stephen, what's the number again of the number of reincorporations out?
I don't have the, I have a whole paper on it with like all the data over 30 or 40 years. So,
Just some kind of approximation, 10 or
30. I mean, out of Delaware every year, 15.
Yeah.
Not even that much, but you know, maybe that many.
A rounding error, you say?
Yeah, they're mostly small. I mean, it's not like, I mean, how many? If they're not, they're very small. It's a rounding error.
I can say that when we do controversial things, and I was involved in 1 or 2 and 7 and 2 or 3, you're in such a leadership position. Your position is so strong that it leaves you free to sort of do what you think is right, with the thought that if you consistently just do what you think is right, everything will be okay. And that's a reflection of the fact that you're way ahead. and you're therefore, and you don't have any dominant in-state corporations, that, as in some states, like Pennsylvania and Connecticut, imposed other constituency statutes, as an example. You can say, well, we don't think that's right, and we don't have to do it because we don't think it's right, and there isn't going to be any 800-pound gorilla that's going to come in and be able to credibly threaten us as we claim that.
Can I add one thing? So I think it's sort of interesting because I've been following, because I do the Times thing, I get all the TransPerfect people emailing me and sending me the TV ads and speaking to me. And I mean, I told the guy, the guy who lost the TransPerfect, I was like, you're doing the exact opposite of what you should do, which is piss off Leo. So you see these threats all the time with leaving Delaware, but that doesn't really crystallize. But I've always been curious. I mean, we have all these companies still that are incorporated outside of Delaware and other states, right? And most of them are old-line companies, and increasingly the IPO market is going to Delaware almost exclusively because of the network effects of lawyers and whatnot. But I wonder what do we say about the corporate governance of those within sort of the paradigms that all of you are setting? I mean, because that's idiosyncratic governance at best, and I'm just sort of curious what to make that we even have still these companies outside of Delaware. And
Especially the model out states.
yeah, and what about them? How do they fit in your model?
It's another kind of network effect. The network effect of being a big fish in a small pond, or that when you pick up the phone and call your legislator because you live in the same community, because you donate to local causes, you get responses because it's the the data. Corporations that incorporate outside their home state is such a small part of the market, 80-something%. I mean, Delaware still gets. Delaware gets 60% of public corporations, but if you leave out those that incorporate in their state of headquarters, then Delaware gets 80-something%, and then Nevada's been growing in that score, but it's still not much of a market. And so I'm saying, look at the home state market as the dominant part, and that's a network effect of being wired to the local community and getting benefits from that wiring.
I mean, the point about the inertia that Greg made was interesting, but it can be overstated. It's a limited use analogy, but I think many of us, when we were in practice, really didn't think the corporate form was in jeopardy. And when the limited liability company came along, there were switching costs. There was a lot of infrastructure that had been dedicated to the corporate form, and corporate law jurisprudence, frankly, but the LLC among privately held companies has really become the dominant form in California, for example. So I think although it's costly, when the incentives become substantial enough, it can happen. Now, it may just be that there emerges one alternative. But I think it's, the argument that inertia might protect Delaware, I know that you weren't going that far, I think, can be overstated.
Yeah, so Bob in his presentation mentioned Ofar's, I don't know how to say his first name, Ofar Elgar's paper. And I think what the finding in that paper is that certain kinds of companies pick Nevada, and they're the state with the N. And there are companies that are small, as Steve was saying, and the thesis in that paper, and then the paper that he has with a co-author, is that it's because the costs of being incorporated in Delaware and exposure to Delaware-style litigation are very, like additional monitoring costs of being in Delaware are very high. So the market is actually differentiating, and then McCall's view on this, I think, is that it's an attempt to insulate managers from liability, but there's a choice there. So a certain kind of company goes to Nevada, and that's not the kind of company that we're talking about as the sort of market leader in, like those are the big giant public companies, the Fortune 500 that you were talking about, Bob. So, and I feel like there's a disconnect. Like we're having this conversation as though there's one kind of company, and that's one point. The other point is we're talking about Delaware like Delaware incorporation controls everything that happens to the company during the company's life. But Greg's point about litigation maybe happens in Delaware, but settlements don't. So the Trulia case is a revelation because the post-Trulia data is that, so Delaware gets tough on these disclosure settlements, and the result is they go to federal court or they go to other states. And so we've got the race to other states all over again. And I wonder, like, so what is, so, and the judges in Delaware are awesome, but they're not hearing cases. So I wonder, how does that factor into the incorporation analysis you guys are talking about? I mean, if I'm a Delaware company, I'm going to incorporate in Delaware, what does that mean? That means I can get sued in Delaware or in my state of incorporation or in federal court, so I have no confidence that I'm actually going to litigate in Delaware. I might be able to therefore settle in a bunch of different places, but how does that all factor into your analysis, Bob, in particular?
It's still Delaware substantive law, and Delaware makes that law, and there are only 10 judges in Delaware that make law, and they dominate those judges in Texas or that are going to apply the law in your setting, and it may be, and I should acknowledge the bias. I think, I don't want to say it's a blip, but I think the litigation over mergers is going away. And I think Delaware is going to outlast that. And then when they do, then the value of getting your case litigated outside of Delaware to get some procedural advantage or get a cut in class action is going to reduce from where it has been the last 5 years. And so I think it will not be a long-term threat to Delaware. On the other, perhaps, I kind of always just walk in, maybe we should tell them what you were talking about before. But we were talking about, and it's important that you know that we've been discounting the data for about 2 hours. And so the question we just had was whether or not Eldar's data says something about what the market is for companies that compete. And Sean's point was that it's not just one kind of corporation, and so you can't just focus on big corporations. And so if you look at the market, the fact that the data is getting small corporations still counts. I don't know if since you've written about that, you feel like jumping in and walking into the room and knocking your coat off.
I'd love to. Yeah, I'm not sure I completely understood the.
Do you think the data is going to make it as a competitor to Delaware? Perhaps is a too simple way to put it.
I think that Nevada is not exactly targeting the same companies that Delaware is targeting. For at least 2 dimensions. One is the size. Nevada evidently attracts small companies, really small companies. And the other is that it attracts companies with somewhat different preference. So we found that states that offer strong protection to managers, like Massachusetts, like the states with the strong takeover statutes, they almost don't lose companies to Nevada. In terms of the companies that are headquartered in that state, in these states, almost never headquartered in Nevada. And they lose many companies to Delaware. So companies that have a lot of protection in their home state, where their headquarters are less likely to choose Nevada.
But that suggests there's competition. And
But it
Delaware has
also
to worry about
suggests that
something.
the candidate to incorporate in Delaware is different from the candidate to incorporate in Nevada. Because for incorporation in Delaware, that does not help the home state. So the candidate to incorporate in Delaware is not attracted to very strong protection in the home state. Whereas the candidate that incorporates in Nevada, that is likely to incorporate in Nevada, is attracted to very strong protection in the home state. So these are different kind of companies. And of course, our other finding was that they are much more aggressive on their reporting behavior. Now, what's the effect of this on value, or do they have different value? I think that, there's no evidence that there's any discount to Nevada companies. We also found no evidence for any discount. And under some tests, it's sensitive to we have to split the sample and so forth, but under some cases even premium for Nevada companies. What does that say? People could have different interpretation. I think it's complicated because, for example, the frequency of restatements is so high, and these restatements were preceded by misstatements of performance. That also affects the key. So it's a yeah.
So to Sean Griffith mentioned that different corporations come in different flavors, they have different characteristics. Do you have any information on what sorts of companies might prefer Nevada?
Right. So what we found, and also Lowell found, and others, is significantly smaller companies, less institutional holdings or smaller, more aggressive accounting behavior, higher restatements, and in terms of value, no discount, and some of them even have, the small companies even have higher value. Yeah, so that's what we know so far. I looked also into some examples of companies that moved from Delaware to Nevada, and I'd like to use examples because we don't know exactly what are the examples in Delaware and so forth. But there are like wild companies there, so I think it's a mix. I think, but it's not that we've proven that. I think that Nevada probably attracts some problematic companies, but also attracts other companies.
Thank you.
And
I wanted to draw Bill into the conversation because one of the things that Sung mentioned and that we all associate with Delaware is the richness of its law. And with cases like Corwin and NFW, there's a concern, at least that I have, and that I think some of the bar has, whether or not procedure and disclosure are going to replace the contextual sort of laboratory that Delaware courts offer, because Delaware courts have really given companies and boards a roadmap for how to avoid litigation by telling them exactly how they can ratchet down to the business judgment rules. So do you see any implications of say, Corwin, for example, for the kinds and the type and indeed the quantity of cases that could?
Well, I can see where it could affect the quantity and to some degree the type and character of cases that go to Delaware. And I would like to think that it's a deliberate and conscious choice that Delaware is trying to design its legal structure so that cases that involve real wrongdoing, real malfeasance, real director or controlling shareholder wrongs are the types of cases that get filed, because those are the types of cases, I think, where the traditional equitable remedies that get deployed can be deployed in an appropriate way, rather than resources and time being expended to the contrary on cases that really are either frivolous or of marginal value or interest in terms of developing Delaware's corporate law. So to me, those decisions from MFW to Corwin, all of those, I think, are a signal that the court's trying to say, we're here for serious cases that involve breaches of fiduciary duty, real core duties that are being broken or violated. And to the extent that there are this other menagerie of cases that are on the fringes of marginal value, that are disclosure issues, which, by the way, I tend to agree that I think Delaware sort of made its own problem in this respect by injecting itself too much into the area of disclosure law. And I think we created so much ambiguity around what was material and what wasn't, that it led to the influx of these disclosure-only cases, and anyone with half a brain could make into an argument about a disclosure that would be helpful or useful to the shareholders. And so I think that truly in these other cases that you mentioned are all designed to sort of redirect Delaware's jurisprudence and its litigation formula, if you will. So I don't see it as a bad thing. It's going to somehow mean less cases are brought to Delaware. I think it'll mean serious cases are brought to Delaware, which is what the judges and I think the community, Delaware bar community, are interested in.
I was just going to weigh in on a small factoid there to emphasize that you may hear a lot about mootness, how mootness cases settle for get plaintiff's fees in a small amount of money, $50,000, $100,000. There's a case called In Re GFI that settled round about the time that Trulia came out, has a mootness fee for additional disclosures in, if I'm recalling it correctly, around $4 million. And the key thing there is that the disclosures were all about malfeasance on the part of a director. And so I think you can still get, a very significant mootness fee if the disclosures that you're getting are about actual wrongdoing. And I think that we need to kind of focus on a difference between just all of the cases that are coming into the courts and the cases that actually have real wrongdoing.
Do you mean failure to disclose?
Yeah, I mean, it was the thing is, it wasn't a disclosure-only case. There was an award for the mootness fee, a mootness award where disclosures were made about this wrongdoing, and then there was an actual cash award to the stockholders based on the wrongdoing. But it's still a mootness award, and I once ran the numbers of all the mootness awards that were done in 2015 and 2016 that I knew of in Delaware. And if you just take that one data point, it's an immense outlier. It's like 50,000, 50,000, 100,000, $4.5 million. So, that's the kind of thing that becomes kind of a significant data point.
Yeah, go ahead.
So I think a couple things. So one, I probably should have circulated our tables, Jill. But I mean, we have all the figures for 2016 on mootness fees and everything. And I mean, just for the crowd. So I mean, so basically last year, 2016, 73% of deals had litigation, down from 96% in prior years. What? Still about double the historical of 2005. Last year, 18% of deals were mootness fees, which some are leftover, some are 2016. All the settlements so far are disclosure only, the amendment settlements, they figured that off. No amendment settlements, changing the terms of the deal. The average mootness fee, median mootness fee, was $238,000 last year, as opposed to disclosure only, which is $320,000. They're certainly lower. And only 5% of settlements last year actually went to Delaware, as opposed to 40% the year before. And last year, 31% of cases were settled in federal courts, which are these 1489 cases, as opposed to 0% in 2009. And then litigation rates are about in half in terms of total suits filed. So you have substantial shifts going on. I don't know, Jill, if you want to add anything.
I mean, and, GFI is obviously unusual for a mootness case because given the monetary recovery, it didn't have to be addressed through mootness, right? It could have been just a normal settlement with approval of the fee award. And so, the sort of titling of that kind of puts it, I know that that's, what the parties did, but I think it is kind of distinct from the mootness cases that, we see in our statistics and that we see following Trulia.
I think one other thing, no one was ignoring forum selection clauses to give witnesses settlements, which is sort of a rumor that's happening. There are some federal settlements to avoid forum selection clauses, but no one was avoiding those. And,
what do you mean by that? What do you mean wasn't avoiding that?
Yeah, we don't actually know that because we don't know if those cases would have been approved even post-Trulia, given the nature of the additional disclosures.
Well, so let me be precise. So basically, for settlements outside of Delaware, okay, none of those settlements in other state courts were with companies that had forum selection clauses that picked Delaware.
But can I flip that? Sorry, Steve.
We should probably do the debate tomorrow, yeah.
I'll just sort of flip that point, because the mechanics of debate, of adopting the form selection clause are unilateral action by the board of directors.
Yeah.
So the moment that the litigation is filed, or the moment that the merger agreement is signed, you could adopt a form selection clause. And so I think that you're counting, like, it's like counting the poison pill the wrong way. Like, you can adopt a poison pill anytime, so everyone has a poison pill. You can adopt a form selection clause every time, so everyone has a form selection clause. That would mean that all of those cases could have had a form selection.
So you need a latent form.
A shadow of a latent form.
Except that it's not entirely clear, based on the existing cases, how a court is going to review a adoption of the form selection clause during the pendency of litigation.
During litigation, but then you could adopt it at the signing of the merger agreement, when you know you're going to get sued, right?
Do you still have a question? Yep.
I just had a comment in response to your question, Iman, about, and you asked the Chancellor, what about the fact that the courts seem to be telling corporations, look, if you do these things in MFW and in Corwin, you can get the benefits of the business judgment rule, and might that not affect basically sort of Delaware litigation as we've known it over the years? And I think it may well affect Delaware litigation as we've known it over the years. But I think if you look at other areas, it's not unusual for the courts or for regulating entities to say, hey, we want you to do these things. We want you to behave in a certain way. Think about product safety. This is what we want you to do. And if you do it, we will leave you alone. But these are good rules we want you to follow. So in MFW, the court says, if you announce at the outset of a transaction, and you can't go back on it, you say, I'm going to denude myself as a majority holder of some of the power I have by creating a committee, making the deal subject to approval of the committee, requiring approval of the disinterested stockholders. If you do all those things, we'll give you a benefit. I think if you step back, that's a way of a governing entity, a regulating entity saying, the court specifically saying, this is good behavior. We want you to do it. And if you do it, there'll be a prize for you. Now, I do think it could affect the world that we've known and that has educated so many of our children, I'm not sure from a societal standpoint that's necessarily a bad thing, in the sense that, say, my law firm, I don't know exactly how many lawyers we have in Gill's firm, is roughly in the same order of magnitude size. I think we have 150 to 60, 65 attorneys maybe in the city of Wilmington. Have you ever been to Wilmington? It wouldn't look like a city that would support law firms of that size, and there are 4 or 5 of them. And in my department, the corporate department, we have, I would guess, maybe 45, including associates and directors, corporate litigators. It's not clear to me that in the next 30 years, the amount of business in Delaware will support that type of system. It's not just affecting the plaintiff's bar if we discourage these suits. It affects the defense bar too, because we make our living, by meeting our friends on the other side of the V in court. And so I do think there are changes happening. I'm not sure they're bad. That's what I would say.
I'd love to follow up with you
Yeah.
on that. We have time for, did you have a question for a couple more questions?
It was related to our previous conversation, but I'll just say about Nevada that also the state is clearly trying to differentiate itself from Delaware. So it's making every effort to suggest that it's offering something else and more protection from liability on fiduciary duty for and so forth. But I'll take one.
Thank you. Adam, do you want to?
Well, I was going to ask the panelists if what they thought of this takeaway. So all 3 of you were very firmly in the camp that Delaware is not going to be dethroned at the end of the day. But if we take all of your presentations together, I kind of came away with like the sum of the parts was a little bit different. And so what I came away is that from Bob's talk is that actually the throne is shared. That the federal government's already there. The federal government has pushed Delaware to the side on on a ton of issues already, from things of products and occupational safety, employee rights, pension rights, so many of the things that corporate decision makers have to do every day. It's already been pushed off. Right? So Delaware is already on the throne, but occupying an increasingly small part of that throne. And Bob ends his analysis by looking at how that shared throne is going to affect the possibility of another state coming in. And I think makes a persuasive case that no other state's going to come in. But the real question is whether the federal government's going to keep pushing Delaware and taking up more and more of that throne. And Jim tells us, well, it hasn't happened basically because of the grace of the Second Circuit. That if a couple of these decisions had gone a different way, the courts had interpreted it a different way, then you might have a very, very different situation where now these cases are really being funneled into federal court and a federal law is developing around it. And with regards to Suhni, I think that it's a great analysis of why that fails at that moment in time. One other thing to consider is that I think the reform movement at that time was very much divided. Brandeis, for instance, a progressive reformer, was opposed to federal regulation. So a lot of reformers at the time thought that states were the answer rather than the federal government as the answer. I wonder if progressive reformers will have that same kind of coalition split in the future. So what we have to come away with is that the federal government is like, Bob mentioned Stuart Banner, our colleague, but I'm thinking of Bruce Banner, the Incredible Hulk, who is just sitting on this chair, and if the right crisis comes along, then all hell's going to break loose, and there's nothing to stop the federal government. So I guess I'm curious, is there anything really in your stories that tells us that there's actually something structural that's going to stop the federal government from taking over more of this space if that crisis arises, if Bruce Banner gets aggravated and becomes the Incredible Hulk?
Okay, 1 minute for each of you.
I think that if we think there are some issues that are inherently corporate law issues, that even if you have a big crisis, there still might be a role. That's kind of the question. Is there something at its core that we think of as inherently corporate law, so that even if there is that big crisis, the federal government wouldn't preempt that before? I guess that's my thought.
And my view is, I mean, one thing different about today is populism is a much stronger influence. But my understanding is that populist anger is less likely to be against corporate players and more likely to go against financial institutions. So that's probably not going to happen.
There are other anomalies where participants cannot use the full reach of their power. I mean, institutional investors can do a whole lot more than they do. The federal government, I gave examples of passing ridiculously ineffective rules, but people believe in shared power. They're happy to have, institutional investors are happy not to go as far as you need to because they benefit in this, and I think that's going to continue. So it would take something, a Bruce Banner crisis, I suppose.
I'm going to go the last word.
Well, I'm not looking for the last word, but I think a part of the story, Bob, and I think your comment, Adam, is that the remarkable rise of the corporation as a separate person meant that corporate law could turn internal and deal with managers and directors, whereas federal regulatory regimes, state regulatory regimes could regulate the corporation itself. And there's a lot of corporate law that has nothing to do with governance. I mean, corporations are very, very highly regulated. And I think that's part of the historical story, because the corporation emerges as a distinct person that itself is regulated. Meanwhile, then, corporate governance can turn inward. And the thing that's ironic to me about corporate law, we corporate law scholars don't deal with the corporation. I mean, we are corporation law scholars. We say very, very little about the corporation. We say a great deal about what happens inside the corporation. But I think that's a big part of that historical story.
Well, that's fascinating. Thank you, everybody. So we're going to pick up our next panel at 3:15, so we have a 15-minute break.
Welcome back. Thank you for a great first panel. Very interesting. This panel will be moderated by Greg Williams. Greg comes to us, of course, from Delaware, as you can tell because he's wearing a tie, where he's with the firm of Richards, Layton and Finger. He primarily represents corporations and their directors and officers, provides non-litigation advice to counseling to his clients, as well as representing them in court, both in Delaware and around the country. He's had particular experience representing board committees in takeover deals and transaction negotiations, as well as special litigation committees investing alleged wrongdoing. He's the chair of RLS corporate department. He served as president of the firm from 2006 to 2008, serves on the board of directors of the M&A Lawyer, and has recently been featured in articles such as Super Lawyers and Law Dragon. And Greg will moderate the afternoon panel.
Thanks, very happy to be here. I'll just start with a little anecdote because there's so many law professors here. I grew up in Delaware. I'm a Delaware native. My father was a blue-collar guy who worked at one of the various DuPont facilities. Everybody's father at the time seemed to work for DuPont. And I went to the University of Delaware. It was the only college I applied to because in my family we didn't understand it made any difference where you went to college. It was just, oh, that's great, you want to go to college. And I was a political science major, and so when I went off to law school, I went to law school in Williamsburg, Virginia, and my second year, I took corporation. I got the case book, and literally 8 of the first 10 cases were from Delaware. And it was Singer versus Magnavox and Duff versus Loft. And when you're from Delaware, not much special about Delaware if you don't know about the whole corporate deal. And so I went to my professor, my corporation law professor, who, like you folks, were very immersed in all this, and I said, I'm from Delaware. What's up with this? And he looked at me, and there was a pause, awkward pause, and he said, well, you're kidding, right? No, I have no clue what's going on here. He said, all right, well, you should come to my office. And so I did, and he explained the whole deal to me, and I was grateful that he was charitable as he was. So let me introduce our great panel. Professor Bainbridge, of course, needs no introduction here. He's the William D. Warren Distinguished Professor of Law. He's taught on subjects relating to corporate law at great universities around the world. In 2008, he won the UCLA School of Law Ritter Award for Excellence in Teaching. And as I said about Jill Fish recently, that really speaks to me, just as a kid who was looking to learn. The people who can really teach and bring it home to their students get my undying admiration. Then Professor Steve Davidoff Solomon from Cal Berkeley has a special interest and expertise in our law and judicial developments. It's a little unique in that the Delaware lawyers and the judges all know Steve, highly respect him. He's a very known quantity in our bar. He is also writes a column regularly, as you know, the deal professor, in what our leader continually, about every other day, reminds us as a failing institution. So, good luck with that. Chancellor William Chandler, he's a partner at Wilson Sonsini. He practices at the very highest levels of the practice of law now. Literally, I mean, jetting around the world, meeting with and counseling boards of directors of very large corporations. Previously, as you all know, was a member of the Court of Chancery for decades and the author of many of the great decisions of Delaware law, the Air Products, Air Gas case, Disney, and many, many others. Wonderfully insightful fellow, and I can tell you as a person who spends his life in the Chancery Court, nobody was better to appear before than Chancellor Chandler in terms of meaningful interaction, respect for the lawyers and their parties, and it was always a pleasure. And Tony Rickey, his colleague, is a former clerk of Chancellor Chandler, then went to Locktel Lipton, and started his own practice, and he has a very interesting practice. Part of it, the Delaware aspect of it, he's in Washington and Georgetown, Delaware, is to represent people who object to settlements. One would not have thought that that was something that you could sort of focus on in your practice, but it has become something that is of interest and importance in Delaware. And so let's start with Professor Davidoff, if we could. And his paper, which presumably you've all read, deals with the rise and fall of Delaware's takeover standards, and it analyzes the evolution of the standards of review that Delaware courts apply to fiduciaries in the M&A context. It's a fascinating topic, and two sort of personal observations. One, when I started in 1982, there were almost no standards. It was the business judgment rule. Entire fairness was around, but not really something that affected life much. And then we had what we call the Schnell-Lehrman doctrine, which was you can't interfere with the vote. That was kind of it. The other observation is that Gil Sparks, who was here, when you hear about these various cases and the standards that they grafted onto our corporate law, about 90% of them get litigated, and so we're very lucky to have him here. It's not an exaggeration. So with that, Steve, I'll get over to you.
Two sort of preliminary things. One is, thank you, Greg. Obviously, I was saying I see Greg's name everywhere, and I wonder where all the rest of his partners are. He seems to be arguing every case, but it's so great to be here. In fact, we're a small group, but a powerful, influential one. I'm so happy to be here. It's my 47th birthday. So, I won't be here. I know we only get 2 drinks, but you can buy me an extra. So that's the first thing. And the second thing is I'm really happy to be here with Milken Center and Joel. They're doing great things. I see them all over the place on the West Coast. And so you guys should be proud of what you're doing. It's just fantastic. So I think the way to think about this is the paper that was in the Dropbox is sort of a chapter. And I think Randall and I have been sort of thinking about this a lot. And we're going to turn this into a law review article. Not because we have a need to double dip on an idea, but because we think we're trying to frame around some theoretical parameters of what's been going on in Delaware over the past 30 or 40 years, try and sort of put out some theoretical sort of framework, as well as sort of think about how Delaware courts should think jurisprudentially about how their multitude of standards work, when they should interfere, what should they be doing, in a market-based system, which I think all of us are looking at. And so the way that we sort of frame this paper is, as Greg said, the 1980s saw a proliferation of standards, Revlon, Unical, Blasius, Weinberger, and basically one way to look at this is that there's been a backing away from those standards over the last 20 or so years, 25 years. And so that's sort of what we're doing at the paper, is trying to explain why that happened, the explosion happened, why the backing away has happened, and sort of how Delaware might approach this jurisprudentially. So essentially the way to think about this is, 1980s huge takeover boom, very little regulation, either state or federal. In fact, the first regulation of takeovers really sort of substantively was the Williams Act back in 1968. But generally speaking, the rise in hostile takeovers brought a big reaction from corporate America in terms of Unical, scorched earth tactics, leveraged recapitalizations, etc. And Delaware was sort of faced with this issue. And way back when I was just a little tiny professor at Wayne State, when no one would return my emails, except for Steve, you always email me. I wrote this article called "The Failure of Federal Takeover Regulation." Because one way to look at this is that, sort of building on the Roe issue of what we had is that, the federal government sort of backed away from federal takeover regulation during the 80s. There was a time when they thought we might get involved with the poison pill, etc. Remember Joe Grunfest used to write those letters and whatnot, and lobbying on 203. But while the federal government came in the 80s, they really backed away sort of in large part to let Delaware act at the end of the day. And so one of the things that Delaware did in the mid-1980s is they jumped in, right? In Unical, in Mesa Petroleum, they upheld the defense of self-tender, right? And basically, in Unical is really the watershed, because Unical made Delaware theoretically a regulator of all takeovers, right? By saying that, you know, any board defensive actions would be subject to a heightened standard, you know, that basically encompassed all takeovers. And that gave you litigation grounds for any takeovers. You know, this was solidified in '86 with the Revlon decision, which created a second higher form of scrutiny. We all know these standards, so I'm going to go pretty quick in sort of framing them for the purpose of the paper. You know, then we had going private decisions, right? Basically, you could see Singer v. Magnavox. One way to frame it is a response to the federal government, right? You had the SEC chairman at the time going on about going privates, saying they were coercive, abusive, people needed to act. You could look at Jim Park's sort of decision framing paper sort of is framed around the battle over freeze-outs, maybe not fiduciary duty cases. But Delaware responded during that time period for a variety of reasons. One, there was a breakdown in the market. Two, it might have been for responding to sort of federal prodding and a fear that the federal government might interfere. And in 1977, in Singer v. Magnavox, they created the business purpose test, something they backed away from a little bit, but still put in a very substantive standard in 1983. So again, we're sort of building up these standards in response to market breakdowns. Again, we're very, very familiar with all this. So in the late 1980s, sort of the high water mark of what's going on. Basically, we have the Blasie's decision in 1988, where now we have 4 standards, right? We started at the beginning with none. Now we have 4 different sort of standards above the business judgment rule. And, you know, then we have Interco, which, you know, articles could be written about where Delaware would have gone and the markets would have gone and Interco sort of stayed. But essentially what you had is sort of at the height of the takeover boom, no surprise, right? Height of the barbarians at the gate, height of sort of dealing with the ramifications of the poison pill, height of companies struggling to push back against takeovers, Delaware trying to arbitrate that market failure. You had the Interco decision where Allen actually forces a company back from adopting the poison pill. And in all of these, it's important to note that this was via litigation. So one of the other things you have during this time period is not just sort of battles over how corporations are going to be done, but sort of the regimentation of litigation as a daily part of the M&A market. So then we had a decline, right? First we had a decline with Unical, Time Warner, Unitran, sort of culminating in Chancellor Chandler's air gas case, right? In which I think it's fair to say he reluctantly validated the management strategy, right? Setting them up for an appeal that they immediately decided not to take, which is too bad for historical purposes, and I blame Jim Lowell for that. But ultimately, I think you know, if you look at sort of Unical, there's also a path that Delaware could have taken. In the 1980s, Unical could have had a substantive edge. Certainly did in Interco, and you know, there's a gradual retreat forced in large part by the Delaware Supreme Court to where we end up in air gas, where you have quite deferential Unical review. And even before that, Gordon Smith and Bob Thompson famously said that you know, Unical was dead, right? There was a brief blip on dead hand poison pills, no hand poison pills, but I think it's fair to say that Unical is not a very substantive standard right now. Revlon and Blasius are also reworked, right? Blasius rarely invoked. Shrine sort of says, and at least one decision says it should be a reasonable standard. I don't know the last time that Blasius was used to overturn a decision. I can't even remember. And also Revlon, right? I mean, we've also had this debate, and I think Chancellor Chandler's talked about this in some of his talks. Revlon is a reasonableness standard. Right? So now, it used to be Unical was the reasonableness standard, and Revlon was the substantive standard. And so, you know, again, you have 4 standards. Gradually, the court has been backing away. And the end result is Weinberger, which is, you know, there's probably a paper to be written about why so many papers have been written about going private transactions, right? You only get about 5 or 10 of them a year. but we spilled a lot of ink, both academically and judicially on it. And ultimately with M&F worldwide, we get what arguably is a backing away, certainly in the Chancery Court as it's been implemented, there's been backing away from this standard in mass commission. So what do we mean by all this? You know, there are a couple of theories about this, and maybe we can talk about it in the Q&A, but I think when Randall and I look at this, we really see this as Delaware intervening in the 1980s to correct a market failure, right? The market failure is the failure of companies to be protected and at the same time being over-aggressive in their defenses. Delaware's role back then was to make sure that corporate governance loans were observed. After that time, you had a decline in the hostile takeover market for a variety of reasons, primarily perhaps the regimentation of the poison pill, but also the rise of other institutions that could check corporations. So back in the 1980s, there were few checks on management. Post-1980s, you had the rise of institutional shareholders, 15, 20 years later, hedge funds, the rise of independent directors, certainly. So, you have other institutions coming into place, which we theorize has allowed Delaware to back away from this. And in large part, we believe, this is probably the most problematical part of our theory, so I think help we have on it would be appreciated. Shareholder litigation is sort of patterned after this. Shareholder litigation started this sort of the enforcement mechanism, bringing in Delaware. In the 1990s and early 2000s, though, it sort of went askew. Randall and Bob, you have a paper which looks at sort of deal litigation and how to influence value, primarily with going private transactions. That was an area during the late 1990s and 2000s. Litigation was valuable, but by the time of the 2000s, deal litigation explodes. You have weak benefits in many cases, although substantial ones in others. Joel has a paper just documenting, I think, just 1 year where $900 million was paid in settlements in recent times. While you have sort of the courts backing away, you have litigation going up at the same time and being more and more ineffective in terms of those suits. And so what we say is a couple of things in terms of implications of changing enforcement patterns. So if Delaware is sort of the market monitor and they backed away because other institutions were functioning to fill that, right? Delaware is a gap filler. Litigation is sort of the arteries of this. They're the ones that feed the blood in and other times. Basically one of the ways to explain the crackdown is not just that we had all these disclosure settlements that were problematical, and that is sort of the main reason, right? But if you want to put a theoretical gloss on this, the need for all this litigation has declined in Delaware. Delaware just doesn't need to intervene as much, right? It's much more happier to take the good cases, right? The 5 or 10 good cases and deal with those corporate governance failures than having to get a look at all the litigation and all the deals. Because most of them now, frankly, are good. And even the ones where we find, this is an editorial, even the ones where we find fault, they're actually pretty good, right? This is not Milken, where the banker's throwing up with the fairness opinion blank, right? There are lapses, but in large part, there's not a sort of, oh my God, what were they thinking? Those still happen. And so, a lot of this, if we take this market model of Delaware, that Delaware is there to sort of act both in terms of rates of litigation and towards of intervention as a market monitor, it clearly says a lot about where we should go from here, both in terms of hedge funds and the debate over short-termism versus long-termism. And basically, Delaware's role is, as some postulated, to sort of monitor the rules of the road, right? Delaware might be challenged in terms of federal proxy rules. We can talk about that in the Q&A. I don't think that's ever really going to happen in terms of usurpation, but Delaware will still continue to hammer and worry about these things. But at the end of the day, they have a dominant position. Just to conclude in my 3 minutes, 2 areas where we're sort of thinking of exploring in the law review article, although we think we can do a lot more in this, is basically looking at sort of hedge funds. Is this an area where Delaware should intervene because there's a market breakdown? We don't think so. We think that I know Leo has talked about sort of the evils of short-termism and hedge funds, but we actually think this is an element of sort of market motivation, market monitoring. If there are extremes, surely Delaware should go in. But on the whole, generally speaking, hedge funds have to create value to survive. They deal with boards of directors and other institutional monitors, and so you have an whole ecosystem that can monitor them independently. And so I'll end on that note, and I'm happy to flesh this out over Q&A.
Thank you, Steve.
Thanks.
We'll go through each of the presentations, and then as we did before, have a Q&A. Professor Bainbridge's paper is entitled Interest Group Analysis of Delaware Law, the Corporate Opportunity Doctrine as a Case Study. And it raises, I think, a very interesting question, using corporate opportunity doctrine as sort of a vehicle. Given that fiduciaries need order, they need predictability, they need clear legal principles and guidelines and rules by which to evaluate potential courses of action, why do the Delaware courts seem to allow these principles, guidelines, and rules to be so ambiguous, so imprecise? Professor?
We're, despite our proximity to Silicon Beach, still dealing with Windows 94 or some such antiquated system, so just bear with me a moment. This piece started out as a fairly simple survey of the doctrine of corporate opportunities and some thoughts I'd had actually teaching the class about how the corporate opportunity doctrine could be tweaked to provide what I think it was the Delaware Supreme Court in Hart versus Kerkorian said, the predictability and certainty that is the hallmark of Delaware law. But I got interested a couple of years ago in a piece that I wrote on the fee-shifting wars in thinking about how the incentives of the various parties that participate in the making of Delaware corporate law influence them. I think one of the interesting things about Delaware's position is that for a variety of reasons, Delaware is largely insulated from the sort of short-term political winds that produce Dodd-Frank and SOX and so on. But there's, I think, reasonable to believe that people respond to incentives, and that Delaware judges and legislators and lawyers do so as well. And so I thought, you know, the interest group analysis of Delaware law is not exactly a subject that has been ignored in the literature. A lot of people have written about it, going back to maybe the foundational Macy-Miller paper in the 80s. But I just wanted to play around with it a little bit to see if I could use it to explain to my satisfaction what was going on in corporate opportunities. Now, in partnership law, of course, we have an indeterminate standard. Right, we probably all teach Meinhardt versus Salmon, and we get to the punctilio of the honor, the most sensitive. And it's always fun to imagine, you know, with your students, the lawyer whose client comes in and says, "Can I do this?" And the lawyer responds, "Well, so long as you comport yourself with the punctilio of the honor most sensitive." But in partnership law, of course, we know that, particularly in Delaware, you can do pretty much anything you want by contract. And so what Delaware partnership opportunity law gives us is what I would call contractable indeterminacy. That is to say, the law is indeterminate, but you can contract your way out of it, as many people do. Often badly, of course, but that's a subject for another day. Now, in corporate opportunity law pre-2000, what Delaware gave us was similar indeterminate standard. I won't go through the law with this group. You all know the law. But you all know that 4 factors are arbitrary. They don't tell us how many of the factors need to be present in order for there to be a corporate opportunity. They don't tell us which are the most important. The capacity factor is to my mind, highly manipulable. The financial capabilities factor is, to my mind, another one that doesn't make a lot of sense, but I got through that in the paper, and you all know that anyway. Plus a judicial prohibition of waiver. The Delaware judges like to tell us that Delaware law is very enabling and facilitates private ordering, but not when it comes to fiduciary duties, Williams versus Geyer. At its core, Delaware law is a broad enabling act which leaves latitude for substantial private ordering, except so long as judicially imposed principles of fiduciary duty are honored. Sutherland versus Sutherland. A provision that would effectively eviscerate the duty of loyalty would be permissible under the LLC statute, but is expressly forbidden by the DGCL. And so, in the corporate law area, they are not allowing us to contract out. And so we have, up till 2000, what I call non-contractable indeterminacy. Then things got, to my mind, rather interesting, because in 2000 the legislature adopted Section 122.17, an amendment to the Delaware General Corporation Law that permits corporations either in their certificate of incorporation or through board of director action to essentially opt out of the corporate opportunity doctrine. And that struck me as rather curious and presented a couple of questions. First of all, given the availability of what I think would be more determinate standards, why did the Delaware courts not adopt a more determinate set of rules? And secondly, why did the Delaware legislature give us the ability to contract out of, or at least partially out of, the corporate opportunity doctrine while the courts are so insistent? Now, the standard story, of course, that we all know is that the Delaware legislature is interested in maximizing its franchise tax revenues, hence my question to Keith about whether the Nevada legislature is similarly so interested, which presumably leads the Delaware legislature to maximizing corporations. But the Delaware bar's interest is to maximize its legal fees, which sometimes means that their interests are in having more corporations, but because there are some sets of legal rules that generate more legal fees even as they drive some corporations away, the Delaware bar may sometimes favor such rules. And of course, the standard story is that I have the hierarchy upside down here, that really the Delaware legislature, at least in this area, is a creature of the Delaware bar. Now, Macy and Miller, in their classic paper, posited that the Delaware bar is dominated by litigators, and that litigators logically should prefer non-contractable indeterminacy. Indeterminate rules mean that you have more lawsuits. If you can contract out of indeterminate rules, that means you have less lawsuits and therefore lower legal fees. But the legislature opted for contractable indeterminacy, which is what I would think transactional lawyers would want. I mean, if I was a transactional lawyer, and well, my theory always was, determinate rules are bad for transactional lawyers, just like litigators, because if you have determinate rules, then people can go off and do things on their own, and they don't need us. But contractable indeterminacy is great for transactional lawyers because it means there's a market for us to come in and do by contract whatever is best for our client. So that got me thinking about the standard Macy Miller story, which is, if the Delaware bar runs the state legislature and if the Delaware bar is run by litigators, why did the Delaware legislature adopt what is essentially a pro-transactional lawyer statute? Okay, so that's one question I wanted to struggle with. My second question is, most of this is judgment at law, right? And the Delaware legislature is obviously an important player, but at the end of the day, most of the Delaware law we teach is not taught out of the statute, but is out of the cases. So we obviously, and this is sort of, again, contrary to the original Macy Miller paper, where they treat the Delaware judiciary as sort of, a given. I think you have to look at them as being a central player in all this, obviously. And so what are the Delaware judiciary's motives? And I'm trying here not to look at Chancellor Chandler. And one possibility, it seems to me, is that Delaware judges are just trying to make good public policy. Ed Rock has a wonderful little paper that I cite in the, I love all of Ed Rock's papers, are wonderful, but there's particularly like one that I cite in the paper where he talks about the Delaware judiciary, and he talks about, for example, reading a Strine opinion where Strine's like really doing his philosopher king thing about what the best public policy is and so on. And so maybe that's what they're up to. But I would argue, right, that if they were doing the right public policy, they would have opted for freedom of contract rather than the rules against waiver. And with a nod to my friend Hillary Sales' paper for tomorrow, we are all contractarians now, right? We all do believe in private ordering. Secondly, of course, we know that judges have incentives to favor the interests of the state and the bar. They're appointed and reappointed by the legislature in a process that the state bar has pretty much a chokehold on. But again, why would that result in Delaware judges favoring the interests of litigators, if I'm right about that, while the legislature favored those of transactional lawyers? And since Chancellor Chandler's in the room, I do want to make a nod to that. Judges are people too, and they are going to seek to maximize a utility function, just as law professors would. And there is some empirical evidence that supports the hypothesis that judges do indeed respond to incentives. The Cohen paper is now an older paper, but I think it's a very interesting paper that has some very thoughtful data. Now, of course, this is not to say that judges are acting venally, right? We all know that it's human nature to incline yourself, to convince yourself that what you're doing is the right thing to do, just as I do every year when I decide to give a multiple choice test rather than essays. So, if we assume that judges are responding to incentives, what incentives are the Delaware judiciary responding to? Well, one possibility, of course, is simply that judges want to preserve Delaware's dominance, that judges want to make sure that Delaware has the maximum number of corporations possible. Why would that be their interest? They serve 12-year terms. Some of them come up for reappointment and presumably would like reappointment, but many of them go into private practice after one of their 12-year terms. So what are their incentives to just sort of favor rules that would attract corporations? More importantly, as we discussed in the first panel, you can make a fairly compelling argument that the main threat to Delaware today comes from the feds rather than from other states. And here, Myron Steele has a paper where he explains, in commenting on Nevada law, he says, well, why won't Delaware go the Nevada, whichever, direction, and follow them in basically allowing you to eviscerate the duty of loyalty by contract and so on. And Myron's explanation in this paper was, well, it would prompt federal intervention. And so I sent Myron an email after I read that paper, and I said, is that really what you think is the problem here? And he sent back an email and said, yes. And then he was at breakfast with us there at the Lowell Milken Institute a couple weeks ago. And I was on the panel with him, and I said again, is this really why you fought no waivers? And he said, yes, the feds would intervene. And I just, with all due deference to Myron, I thought he was tremendously beneficial figure. I think he's a great guy. I like him a lot. I respect him a lot. But they just don't buy this. And this goes sort of to my attitude about a lot of what happened in the first panel, which is, yes, federal intervention happens, but it's episodic. It's driven crises. You know, I had hoped that Usha Rodriguez, our good friend from Georgia, would be able to be with us, and unfortunately she couldn't. And Usha's got a paper out that sort of challenges the, oh, it only happens in crisis model. But, you know, I mean, come on, the examples she comes up with are stuff like, you know, back office paperwork acts and things. Major changes in corporate governance at the federal level happen as a result of significant crises. So I just don't think federal intervention is something that Myron really had to worry about. So I don't think they're trying to preserve Delaware's dominance. So where does this leave us? Well, if we set aside that Delaware law in this area is simply the product of selfless public servants trying to make the best law that he can and or maximize the interests of all the public, or all of their state citizens, we're left with thinking about the lawmaking in this area as a three-cornered project in which the players in each corner have their own set of incentives. And when we look at the state bar, or the state judiciary's incentives rather, what strikes me is that the explanation that makes the most sense is reputational. If it were not for Delaware's dominance of corporate law, how often would Delaware courts be mentioned in the New York Times or Wall Street Journal? Particularly chancellors, right? How many times do trial court judges in other states make it onto the front page of the Wall Street Journal the way Bill Allen and Leo Strine have done from time to time? And somebody said, you ever see a Nevada judge in an academic conference? You ever see a Delaware judge in an academic conference? I mean, we follow them around with our last paper going, cite me, cite me, cite me, cite me, cite me, cite me, please cite me, cite me, cite me. I mean, they're rock stars and we're their groupies. Status matters. People with status are going to protect it. And so it seems to me that reputation probably is the explanation that fits best, and it's the explanation that I think explains the most. Bright line rules reduce the amount of litigation, hence the preference for indeterminate rules. The way you enhance and maintain your reputation is by having opportunities to demonstrate your expertise. If you don't get litigation, you don't have those opportunities, which is why I'm going to be very interested in what the folks have to say about Trulia and whether, you know, how Delaware is going to respond with the exclusive forum issue. Conversely, contractual standards reduce the amount of litigation, probably. And that means, again, if what you're looking for is opportunities to demonstrate your expertise, you don't want people contracting out of giving you those opportunities. Hence, non-contractability. So it seems to me that explains sort of how we get Bras and Williams and those cases. Still, the puzzlement, though, is why the legislature went the other direction and why the Delaware legislature went with a seemingly pro-transactional lawyer litigation reducing rule as opposed to pro-litigation litigation increasing rule, and perhaps we can discuss that in the Q&A. Thanks.
We're going to cancel your intended topic, and we're just going to have you respond to Professor Baker's.
Fine with me, I'd love to start right now. I got a few corrections, I think.
Okay. We're going to stick with the script, and Chancellor Chandler and Tony Ricky's very thoughtful paper, The Trouble with Trulia, reevaluating the case for fee-shifting bylaws as a solution to the over-litigation of corporate claims. just as a little background, as somebody who was very much in the weeds of a lot of these disclosure settlements, it was a practice that many of us found troubling. It certainly made perfect sense for our clients. They were in large deals, they were getting releases. The company was paying an amount of money which wasn't material in the grand scheme of things, and the litigation went away. From a certain standpoint of a certain aspect of the plaintiff's bar, primarily, that worked well for them as well. But there was something very unsettling about it, and to me, the thing that was unsettling is when you looked at the disclosures that were informed the settlement, you couldn't really honestly say that there was anything here that was going to affect anybody's view of this transaction. And so we needed reform, and it came in the case of Trulia. And Bill Chandler and Tony Rickey have given a lot of thought to whether what Delaware did in response to this problem worked, and if it didn't work, do we need to rethink where we are?
So while Tony gets to the podium to get the slideshow, for obvious reasons, I won't be doing that. Greg's right. Tony and I did this paper sort of to think about whether the solution that Delaware attempted to apply to this problem was being successful or not. We refer to the solution as the grand bargain, and you won't find that anywhere except in our paper, but that's how we refer to it. And so I'm going to talk a little bit about how we got to Trulia, and Tony's going to talk about sort of the post-Trulia solution and how it's working. I don't need to spend much time explaining the background of what precipitated Trulia and what precipitated the grand bargain. Everyone's familiar with the statistics about the tremendous growth in the litigation that was being filed, the sue on every deal phenomenon that led to not only multiple lawsuits, but multiple jurisdictions being used for those lawsuits. Everybody's aware of that trend line. And as Greg just mentioned, everyone's aware of the increasing phenomenon of many of those settlements being just simply for disclosures. There was no money. The stockholders aren't getting anything out of it. This is the peppercorn, which has led to the article of some of those here, which is that's the problem. And so the background to this is, that I think is sort of music in the background, is at the same time that this is happening, you have some folks in the academic community who are saying, well, Delaware's potentially going to lose its cases. And that's the way, it shapes the law, the Delaware corporate law. And so if there's a threat that these cases could go to these other jurisdictions, then the music stops in Delaware, and that's not good for Delaware. So that's sort of playing in the background while this is happening. Now, what happens next is you get to 2014, and you have the ATP decision. This is the very controversial decision by the Delaware Supreme Court that implies that fee-shifting bylaws can be permissible as a solution to this excessive litigation phenomenon. It's a non-stock corporation, but the language in that opinion very clearly signals that corporate law principles might apply. The court even says there, the opinion was by then Justice Berger, I believe, that the fact that a bylaw shifting fees is for the purpose of deterring litigation does not make it an inequitable or improper purpose. So, companies looked at that and lawyers looked at that and thought that this might be a potential solution for the excessive litigation and multi-forum litigation problem. Now, remarkably quickly and almost furiously, the Delaware Corporate Law Council responded to ATP. Within 2 weeks, they had drafted legislation that reversed the decision of the Delaware Supreme Court. There was, equally remarkably, in my opinion, a fast and furious response from the United States Chamber of Commerce, from the Delaware Chamber of Commerce, from the DuPont Company, from other companies, pushing back against this outright ban and outright reversal of ATP. And it's an unusual thing, but it backed the legislature up, and they paused and said, let's study this a little bit. And they sent the council back to look at it to see if there was a more nuanced way of reversing ATP, but the council's own wisdom, it came back the following year, 2015, and it proposed legislation that is what we term the grand bargain. That grand bargain was simply this, that they would adopt a statute that expressly approves and authorizes the adoption of exclusive forums, as long as it's Delaware. Now, they didn't really need to do that because the Court of Chancery had already said that that was permissible under Section 109. But that was part of the bargain. The other half of the bargain was that fee shifting would not be permitted either in bylaws or charter provisions. And the theory of this bargain, our premise is, the theory of this was that, and it's actually expressed, I think, in the council's position paper that they used to support the legislation, is that this will drive litigation to the Delaware Court of Chancery. And so the court and the judges don't need to worry about that loss of cases. And it will give them the strength and the courage to scrutinize these cases that are coming in, because they won't have to worry about them fleeing to another jurisdiction, because companies can adopt forum provisions, steering them all to Delaware. So it will give the judges, in a manner of speaking, even more courage and backbone to scrutinize things and prevent the over-litigation phenomenon from continuing by being more rigorous in that process. So that's what happens when Senate Bill 15 is adopted and passed and signed by the governor. And then the next response that you see is, a variety of responses. Number one big question was, would other states similarly enforce these forum selection provisions and bylaws? And the evidence came in, despite an initial case that went the wrong way, Galvez, all the other cases gradually, one by one, courts in other jurisdictions, including California, which was the big question mark, would California follow the lead of other states and follow Delaware's lead, recognized these forum provisions, even though some of them were being adopted on the day of the merger, not on a clear day, but actually in the context of a transaction. All the cases from all the other states seem to suggest that they're being enforced uniformly. So that question was answered. And yet, what happened, and that's what the chart sort of shows you, is that we found that many of these cases now begin to migrate. They are nevertheless migrating out of Delaware. And the optionality of a forum bylaw provision gives companies the ability to allow a case to go forward in another jurisdiction if it consents to that or allows it to, in its headquarters, for example, state. The other phenomenon which the chart or the graph there dramatically illustrates is the filing of increased numbers of federal securities type claims, which may not be affected or barred by the forum selection clause from being filed there. And that's the increasingly prevalent response, which led to one commentator recently saying in the Cornerstone research report that when Delaware's judges shut the door on merger settlements that provide no measurable benefit for shareholders, they file in federal court by bringing claims that can't be moved back to state court. That's rational forum shopping behavior by plaintiffs' lawyers trying to maximize their returns. And so when one door closes, another door will be found, or as another expression has it, water will always find a way. So plaintiffs' lawyers will always find a way around whatever obstacles or whatever ways you try to steer the direction of litigation. So I'll stop there. I'll let Tony take it from here.
So I was going to open my remarks by saying I'm the only thing standing between you and going home. Now I can say I'm the only thing standing between the Bainbridge Chamberlain cage match. So this is going to be very brief. We've looked at the situation 1 year, or a little bit more than 1 year following Trulia, and looked at a certain number of cases that had, and settlements that have been approved. As you can see from the slide, there are not very many cases, or there were only 3 disclosure settlements approved within Delaware, within a very relatively narrow range of values as far as what plaintiffs got in expenses and fees. Outside of Delaware, we're aware of 23 cases, and I'm aware that Mr. David Sullivan probably has better numbers than I do. But the settlement values there that we know of are between $1 million and, in one case, a little over $160,000. And you can divide these cases up between, into 4 different buckets. Within Delaware, these kind of settlements are almost extinct. On the other hand, the court hasn't failed to approve a disclosure settlement since Trulia. One reason for that is that plaintiffs are pursuing alternate resolutions. In some cases, they're simply withdrawing their settlements. In some cases, they're seeking a mootness path. In at least 2 cases that I've personally been involved in representing objectors, an objector shows up to a settlement that files an entry of appearance, and the plaintiffs pulled the settlement the day before the objection is due. So there just isn't a lot of opportunity for the court to rule on these cases because they're not being brought. Outside of Delaware, these settlements are still being pursued. And the most successful strategy, if you are a plaintiff trying to get your settlement approved in a court outside of Delaware at post-Trulia, is just don't mention Trulia. If you don't put it in your final approval papers in front of a non-Delaware court, and no objector shows up, which in the statistical majority of cases it doesn't happen, the judge is not going to, in many cases, see the Trulia case. A couple of good examples of this that are in our paper are the Affymetrix case and Sloan v. Rentec Nitrogen Partners. And I think the most interesting part of these cases is not the opinions or the orders, but if you look into the briefs that are filed and how this litigation plays out. In the Affymetrix case, there's a wonderful transcript that's cited in our paper where the judge specifically asks for further briefing on, is there any case law on this? Plaintiffs come back with a multiple page additional briefing, mentions, I think, 6 Delaware cases, nothing on Trulia. So if you're a plaintiff's attorney trying to get this kind of settlement approved, that's your strategy. There are a few cases outside of Delaware where courts have confronted Trulia and distinguished it. North Carolina Business Court is one of the few cases, or a few courts, to have cited to Trulia sua sponte where there is no objector. Originally, the North Carolina Business Court had suggested that Trulia's enhanced scrutiny wasn't going to be applied in North Carolina. There's a little bit of case law suggesting that the mootness fee path is not available in North Carolina. But the most recent case suggests that these disclosure settlements may be subject to greater scrutiny in North Carolina. On the other hand, there's New York. This is not in our paper because it's an opinion that just came out. It came out after we uploaded our paper to the website. Recently adopted a new standard for considering disclosure settlements. It most notably does not focus on the plain materiality of disclosures, and it adopts a entirely different take on how these settlements are approved in New York. And I originally wasn't going to speak much on this, but given what was said in the first panel, I'd like to expand upon it. Other courts have distinguished Trulia based on materiality of disclosures, and by finding that the settlements that were presented to the court did in fact have material disclosures. And I can't remember who commented on it in the earlier session, but the question of do we want district court judges in 50 states deciding what is or isn't material under Delaware corporate law? Well, or what constitutes material disclosure? Well, some of these disclosure issues, when you get down to the nuts and bolts, are very complicated, very detail-oriented. I mean, for instance, the question of if you have a comparable companies analysis in a banker's presentation, does it need to present every single multiple for each of the comparable companies? And in Delaware, the answer is no. Or I would at least argue that tend to be no. In other states, that may not be the case. And that may complicate things for transactional lawyers going forward. Finally, outside of Delaware, there's 2 cases that have followed Trulia and adopted the same standard. Verdia v. Aguero, that was a case where I represented Professor Griffith as an objector. And in the 7th Circuit, a recent Milken opinion where Judge Posner adopted the Trulia standard. And notably, both of those decisions involved stockholder objections, which is how the case gets before the court to begin with. So, and I'm going to go very quickly through these slides because it's all in our paper. Question is sort of, where does Trulia go from here? And are there means for Trulia's influence to be expanded? One question is, or one possibility is that we wait and see that Trulia, much like form selection bylaws, will become more influential over time. Personally, I wonder what the mechanism for that will be because, as I said, if there's no objector, it's unlikely that the case is mentioned in front of a non-specialist, particularly from a non-specialist non-business court. One possibility is that courts could take this into account when they consider adequacy of counsel or lead plaintiff awards. Another issue that we touch upon is the accessibility of Delaware law in this very complicated disclosure or materiality questions, because often these are handled in transcript opinions that aren't immediately available, frankly, even to many Delaware lawyers. We suggest that perhaps these could be put into an online database that non-Delaware judges would be able to see in what are often non-adversarial hearings where they're doing their own research. And I touched upon the Gordon v. Verizon Communications case, the New York appellate case that adopted a new standard. This is a challenge, I think, to Trulia, and if this kind of thing happens in different jurisdictions, it'll be a challenge to the grand bargain, because other courts can adopt different standards. And finally, we suggest that if a significant portion of M&A activity remains subject to automatic stockholder challenge, commentators and practitioners may seek solutions beyond the grand bargain. And we suggest that such reconsideration ought to include a reevaluation of fee-shifting bylaws. We point out a few of the advantages that fee-shifting bylaws have over the outcome of the grand bargain, and adopt some counter-arguments to some of the criticisms of fee-shifting bylaws. And since I'm pretty certain I'm about to get my red card, we can talk about those in the Q&A, or they're all in the article. Which just leaves me to say thank you very much, and thank you for the opportunity.
So, a question, see if we can bridge some gaps here. Chancellor, it doesn't seem to me to be too much of a stretch or too controversial to say, and I'm echoing something in Professor Bainbridge's paper, that you judges are part of the Delaware legal community. We are a small, close-knit community. Gil just left. I don't know what that means.
It's getting smaller.
We're still part of this, yeah. But we're a small, close-knit community. We're friends on both sides of the V, and we're friends with the judges. And we know each other's wives. And we do have a wonderful practice in Delaware, both as judges and as attorneys. It doesn't seem to me too much of a stretch to think that judges at some level, perhaps subliminally, perhaps subconsciously, would want to preserve that. And that desire to preserve it could infiltrate their decision-making. What's your reaction?
Well, I'm not a psychologist, and it's possible. I can't rule out psychological influences on anyone. All I can speak to is my own personal experience. I did it for 22 years. I did it 14 as chancellor and 8 as a vice chancellor. I was reappointed 5 times during that period of time. It just happened. Judges around me and myself were fixated on trying to do one thing, which is get the right answer. And I wasn't thinking about whether I was going to get invited to Tulane and whether I was going to get hosted at some conference. I wasn't thinking about those things. They never dawned on me to think about that. Every day was a struggle to get through the docket and the cases that are waiting for a decision and to make sure that we got the right decision. And my view always was, and I told my law firms that, there Their job was to keep me honest and make sure I didn't make any judgment calls instinctively without thinking carefully through it. And that whatever I did would reflect on me someday in terms of everybody's reputation as a reflection of what their life's work is about. And I'm comfortable with whatever that is at the end of the day. But, you know, I understand Professor Bainbridge's concept here, but I don't really agree with it. I don't think judges are consciously or thinking about trying to burnish their image or their reputation or get themselves invited to conferences by fashioning the law in a certain way. I mean, understand too, Steve, I was a trial judge. I don't make the rules. I really don't. I apply them. In the Airgas decision, you could tell maybe there were places where I didn't really like to apply them, but my job as a trial judge is to apply them. I don't get to make the law with respect to what the corporate opportunity doctrine might be optimally if I was to be a legislator, for example, or a Supreme Court justice. My job is to apply what the Supreme Court's given me in the Bras decision in every case that comes in front of me. That's what I'm trying to do to the very best that I can. So that's the way I approached it, you know, Greg. And I have to believe that my colleagues were in the same vein as me, at least. That's my impression from being around them. Everybody was just struggling every day to get the right answer.
Reaction on this topic, and I view the topic.
Well, can I just
yes,
briefly? It's not a question of consciously thinking about it in terms of what maximizes whatever. When I make decisions about how to teach a class or what exam structure to have, hopefully I'm not thinking about you know, what's going to get me you know, the Rutter Award for teaching or you know, good student evaluations or whatever. Hopefully I'm thinking about, you know, what's the best pedagogical thing to do. When I'm thinking about, you know, what article to write, I'm not thinking about, well, you know, what's a topic that might land me on Bob's top 10 list this year. But nevertheless, if you believe rational choice theory, we're all rational actors and we all respond to incentives and we all try to maximize our utility. And we do that not at a conscious level often, it's often unconscious. And you know, sometimes if we think about it, we can sort of consciously figure out what we're doing. You know, but a lot of it's unconscious. I give an example of, you know, I just hate the Socratic method. And so I came up with all of these reasons why the Socratic method doesn't make any sense. And I gave this talk when I got the Rutter Award about how, you know, first it was my little dirty secret, and then kind of word got out, and nothing bad happened, so I lectured more, and then nothing bad happened, and good things were happening. And so I kept lecturing more, and then I was pretty much 99% lecture, and then they gave me the Rutter Award, right? But I wasn't making those decisions on the basis of trying to get that award. I really, you know, had myself convinced that this is the best way of teaching. Is it? I think so, but, you know, a lot of my colleagues don't. And they say I do it because, you know, I'm lazy or whatever. And so, you know, it's not a matter of consciously thinking. It's thinking about judicial incentives is not a way of thinking about what judges actually are thinking as they make decisions. It's more, if we respond to incentives, what are the incentives we're most likely to respond to?
The point you made about, Professor, about Myron Steele and being concerned about federal intervention. Let's just assume that all judges aren't as pure as chimps or chimps. I'm not saying that they're impure, but let's just assume that for purposes of discussion.
You should know the judge like before.
If there are judges, Delaware judges out there who have at some subconscious level a motivation to keep Delaware where it is, and that in some way infiltrates their decisions, and I really open this up to the group as well, doesn't that in many cases result in them really trying hard to get it right and to not go too far on either end? Because it may just be paranoia, but I do think in Delaware we have had a concern that if we got too pro-management and we really stifled stockholder rights, there could be some federal intervention, and that may just be paranoia, but I think it's something that we think about. And then secondly, I think that we as lawyers think that, if those damn courts get too crazy in favor of the stockholders, we worry about whether this inertia I talked about will save us all from corporations leaving. And so if the judges are being motivated at some subconscious level by trying to protect Delaware, I posit maybe that leads to some relatively good law, good balanced law being created. Professor David?
I think it's not pro-shareholder or pro-director. Given the discussion of both the papers, it's do judges consciously, picking up Steve's thesis, do they consciously pick rules that maximize the role for judges in the game by indeterminate rules? And I would ask the Chancellor not to speak about his colleagues, but to speak about his bosses. Because I've read Supreme Court opinions for a lot of years in Delaware, and my clear sense is that they, and I haven't done it statistically, is that they lean toward rules that make you come back to them to know what the rule is. And I developed two theses for that. One is that they are subconsciously or consciously preserving their role in the system. The more positive one that I actually lean to is that they understand that Delaware law is best made by a multiple player game, and their job as judge is to let the players play and to keep everybody in the game. And indeterminacy, this goes to the question of what Steve would think, indeterminacy actually has the value of sending the players, keeping every player in the game and sending the players back to the table to negotiate. And that is a positive explanation for the indeterminacy that we see in Steve's cases. What do you think about your bosses? What do you think about?
Differently, and it's a wonderful question. It is a common theme in our law that there are no bright line tests. We like to say that. That's one of the things that you can safely say. Well, we have very few bright line tests in Delaware law. Chancellor?
No, I would agree with that 100%. I mean, I don't think we should be embarrassed by that or concerned about that, frankly. And I would agree with you, Bob, that I think probably at the appellate level that there is a sense of, first of all, they can legitimately, as an institution, announce new policy, new rules. And I think they are sensitive to, frankly, basing what I know of them, they are sensitive to keeping the rules from being so linear and so rigid that you are going to end up having people foreclosed from making arguments or claims potentially that might have some merit to them. And so the more flexible those rules are, you call it indeterminate, I call it flexible rules that allow arguments to be made contextually based on the facts, means that you aren't foreclosing players from having potential roles later on. You're giving a wider expanse. I think that's perfectly legitimate to say that of the Supreme Court of Delaware. I don't disagree with it. I think it's a good thing, not a bad thing. I was a trial judge. That's not my job. I just apply what they tell me is the rule. Even if I don't like it, I'll apply it.
But you kind of hinted to them in their gas that they need to do something.
I did give them a strong hint. I was hoping there would be an appeal, and that once the appeal was taken, they could either say, Chandler, you're right, we got this wrong, we got to fix this. Or they'd say, no, idiot, you're wrong. We've had it right all along, you just didn't understand our rules correctly. It's just the way they usually reverse it. They usually say, you just didn't understand our rule clearly enough. Let us explain it to you again. That's what, I've seen them do before, and I understand it. But I was hoping that would happen. It didn't happen in their case.
Yeah, first of all, I didn't know Bainbridge was a spoon feeder, but thanks for telling me. The problem I've got with your thesis, Steve, is its partiality. That's my response to Bob's. Why in the LLC and partnership world are the rules different? There is no indeterminacy. It's categorical. Are you saying the judges have no influence in the legislature? Because if it's a multiple player world, we're talking about corporate law, but the elimination of fiduciary duties, I know you can talk about, was the waiver complete? Is there still this good faith covenant and so on? But it's a pretty determinate world in the LLC partnership. So your account seems partial because you picked this nice case study, but can you really generalize?
I don't know if you can really generalize, but the LLC context, it seems to me, is consistent with at least part of what I'm saying, because as I understand the evolution of LLC law, the principle of freedom of contract was embedded in the statute, right? If you think about cases like the Elf case out of Delaware, that they were simply saying, well, freedom of contract is the policy of the statute, right? And freedom of contract was baked into LLC law from the beginning by statute, and so it is an interesting question. Why did the legislatures, maybe Delaware and elsewhere, seem to favor freedom of contract in a way that we see the Delaware courts in cases like Williams and Sutherland reject?
First we go to Lynn and then Gil. Gil?
Yeah, so a little bit of inside baseball. The corporation law section is actually divided into two camps. There are the corporate lawyers, and then there's a whole different operation with a separate subcommittee of LLC. And I fought the battle for years, and I am sure that my successors have fought the battle subsequent to that. And it is to answer the question of, well, we can do this in LLCs, why not corporations? And there has been a consistent concept in the Delaware bar that we can't do that. And the reason for it is that given the size of our corporations, or many of our largest ones, what we're selling is a gold standard. And you can tell me that, well, you can cure from disclosure, by disclosure, saying something in the LLC, in the corporate context. By the way, we don't have any fiduciary duties here, but nobody's going to read it. And then it's going to come up in some case, and it's going to be awful. So we've always drawn a very strong wall between the two concepts, and I think that goes a long way to explaining why we are where we are.
Could I just briefly ask them, where did 122.17 come from? The provision that allows you to opt out to essentially opt out of the corporate opportunity doctrine in your certificate.
Yeah, but I just think that was something that we recognized that there were types of corporations where there were investors who wanted to invest in a company that they knew had conflicts either with another company that was affiliated, which is where it usually comes up, or perhaps with a major stockholder, major individual stockholder. And we thought that they ought to have the freedom to do that. But that one doesn't come up. That's not the same thing as some concept that there are no longer any fiduciary duties applicable to Delaware corporations. And if you ask me if there were one thing I could think of that really put us at risk, would be to ever move in that direction with public companies. There's a corollary to that, and something I've always felt strongly about, but we don't have the power to do much about it. It's an area where maybe the federal government ought to cooperate with Delaware. And that is, I don't believe that there's any place, for the reasons I just stated, for public LLCs. I think LLCs are a wonderful vehicle for private ordering among small groups of stockholders. But I can tell you, having represented a lot of these pipeline companies and other companies, I don't think any of our stockholders know that there are things like special approval committees and some of these other weird things that have grown up in the LLC world. They just think they're investing in a New York Stock Exchange company stock. And so it's too bad because we can't stop that. But at least we can say Delaware corporations are not going to permit, we're not going to permit abrogation of the
Greg,
fiduciary.
can I just ask a question of Gil about that? Why for public corporations don't you view public market pricing as adequate protection for that, especially given the level of institutional ownership in Delaware corporations and the presumption that institutional investors can at least identify the risks that these kinds of things would pose?
Well, because they're institutional, notwithstanding the fact that we like to think about everybody being an institutional investor. Everybody isn't an institutional investor. But number two, I think you've got to start with some base, some concept of what, of how this entity operates. And it would throw away 100 years of case law to say we operate without fiduciary duties. And to me, my guess is nobody's going to really welcome that. I don't think the investment community would welcome that. I don't think anybody would. I don't think management would want to welcome that because I think it opens up all sorts of Pandora's boxes.
Can I just, we're on that tangent, to Jill's point, having written for the Times over 8 years, I remember, anyone remember when Abercrombie and Fitch tried to reincorporate into Ohio? None of their investors, the proxy advisors, was initially recommended for it, and ISS was going to recommend for it, and none of the investors really appreciated the nuances of Ohio law versus Delaware law. I don't even think I taught in Ohio, so I sort of know, but I don't think they look at those nuances, Jill. I think it's an inefficient market. Now, they might on Snap sort of get all that, but I think sort of the points about fiduciaries and waivers are not.
Yeah, that's the problem. That's the problem.
Certainly by large investors, even hedge funds don't. A number of conversations I've had with hedge fund managers about the differences.
So they're not going to focus on it, even if they're sophisticated, and then something's going to come up that is just egregious. And all of a sudden it's going to be, wait a minute, Delaware let these people get rid of fiduciary duties. And while they otherwise, management would have been tagged for whatever horrible thing happened, now they won't. And
Yeah.
I just think that's something we can't withstand. I mean, we can withstand occasional articles about dogs filing certificates of incorporation and the like. I don't think we could withstand it.
But I also think one, just as much as the other, I'll leave. I think, there are bright line standards in Delaware all throughout, but if there's a bright line standard, you're not going to sue. So you know what the rule is in these cases. So, I think there are indeterminate standards, but a lot of this in corporate law is through the bright lines that people just know.
Those are certainly the right line rules to keep.
I wanted to switch a little bit to what Tony was talking about. The plaintiff's bar, it's just troubling to me that, they're not talking about truly, maybe they have to search their conscience when they're writing their briefs in favor of approving of the settlement. But I wonder, is the board of the company that's settling, are they breaching their fiduciary duties, possibly a duty of candor, by just sort of shutting their eyes to the plaintiff's inadequate briefing?
It's a good question. At least in my experience, when I've been litigating these, very rarely at the final approval stage do the defendants say much of anything.
But they are approving, the board is approving the settlement, and they're...
What are you going to sue them for?
For settlement.
No, it's got to be a breach of
But
duty.
he's representing folks with a...
It's the lawyer.
Candor to who? It is good for the stockholders to do this settlement.
That's why they're engaging in the collusive settlement.
And you got to say that it's collusion or conspiracy with lawyers to do something that's good for stockholders.
I mean,
What's the closest case you got?
I would be looking at that as a case for waste. I would think that would be, that's often called one of the more difficult cases
ones
for anybody to win. So.
But what's troubling to me is we have this collusion between the plaintiff's bar and to corporation to settle a case, basically at the expense of stockholders to let the board off the hook.
Well, from a director's point of view, though, is that really a waste of corporate assets? I mean, would you rather go take this case that you think is, I'm going to put myself in the shoes of a director, none of whom are my clients, so this is completely hypothetical. But if I'm sitting there as a director, do I want to spend $1 million to litigate this case to trial, or do I want to spend $300,000 to settle it? And if that's honestly your position as a director, where is your bad faith? Do you have some kind of responsibility to your stockholders to go fight this case to the death because the plaintiffs have failed to cite authority in a brief?
But they might not.
Well, I thought lawyers had a professional responsibility to bring to the court's attention applicable law, which raises in my mind, is truly a law any more than Caremark? I mean, there's settlement cases, and there's a lot of dictum about standards, but are they saying, well, truly is not really law because it's a settlement case?
I would tell you from defense counsel standpoint, I've not had this situation, but because it wouldn't happen in Delaware, but were I involved in a case outside Delaware and we had a disclosure settlement and the plaintiff's papers didn't say anything about Trulia, I hope I would say, let's tell them they need to put a footnote in there saying why this case, the settlement of this case comports with Trulia because we think these disclosures are material, they can say whatever they want. But I think for counsel as opposed to the board generally we can get to that level of what's said to the court, but for counsel that's a tough spot, I think, if you're not mentioning Trulia. Let me go in the back.
Can I just follow up on that?
Yeah.
I'd like to say, first of all, having litigated these, I hope I end up against you in one of these outside Delaware, because that just hasn't happened.
Yeah.
I actually put a quote on one of my slides from a reply brief in a case where I represented Professor Griffith, the case in New Jersey, where a attorney who litigates in the Court of Chancery all the time wrote this. First, they described Trulia as a January 2016 opinion authored by a Delaware trial court judge. That's a statement that I would actually love to be sitting in the gallery and watching somebody say that in front of the Vice Chancellor. But they actually argued further, to the extent that Trulia altered the analysis of disclosure-based settlements in Delaware, which is far from clear given the post-Trulia final approval orders in DTU and MPS Pharmaceuticals, the Court of Chancery has recognized that the previous decades-old standard should apply to settlements that were reached prior to the shift in case law, such as the one here. Now, I was very fortunate in this case to actually have the transcript opinion from MPS Pharmaceuticals, which we gave to our local counsel when we argued, and he stood up in front of the judge and said, Your Honor, this is what Vice Chancellor Lowell actually said. He said, Trulia is the law. But unless you have somebody who is going to be giving that transcript opinion to the judge, that's never going to get there. And as to your point, I can't speak to legal ethics. You probably don't want to know. I passed the MCRE. But there is, to my mind, a question of adequacy of representation. And I do think that's something.
I'm sorry, just on this point.
Yes, go ahead.
Why aren't the law clerks and the judges raising this sua sponte?
In what sense?
If it's not raised by the litigants, why doesn't the court raise it sua sponte?
Well, you would have to have a court or a judge. I mean, if you're in a federal court, you're going to be in front of a judge who probably has a criminal docket. They probably have 100,000 other cases, and this is a settlement. I think it would be expecting a lot of a trial court judge in a federal court to have their clerk, looking for the little yellow mark on a Westlaw citation for every case that's cited in what's a final approval.
And the scrutiny of settlements in Delaware, that's a relatively new phenomenon. I mean, that's in the last, I would say, let's just call it 10 years or so. I mean, it used to be that you would go over with the settlement and as defense counsel, I might bring, the record jacket just to look official, but I wasn't expecting to ever answer a question or say anything. That's all changed now because of course. So I think in other jurisdictions, it's probably much like it was in Delaware for years and years, where the judges say, you want to get this off my docket, you do too? God love you. Jim.
I was going to say it's in the interest of the shareholders to settle those suits. It's not just a question of legal fees that are being expended, but the uncertainty you create for deals. You can't have a deal tied up in court for very long before it blows up in the market for other kinds of things. So I'm not sure exactly how it plays out in the courts, depending on who the clerks are, et cetera, but the pressure to get the deal done in the interest of the shareholders is there, which militates in favor of these kinds of settlements.
I don't think it's in the interest of shareholders to settle these cases because the shareholders are the ones that are waiving their rights in the settlement. And the cases potentially mean potentially mean real money for shareholders. So the example that is often given is the rural metro case, which settles for supplemental disclosures, and then another group of attorneys come along and take the case away and then extract, I forget, 350 million or whatever the number was, a large number. And so it's the shareholders actually who are losing out. They're getting no value in the settlement itself, and they're waiving rights that could be valuable if somebody would just look. And I think the pernicious aspect of these settlements is that it's we're not allowed to say it's like a minuet where the sides both know what steps to take, but there's no actual litigation in these cases.
So two things. One, I think someone should sue on these mootness fees and claim they're waste if they're looking for a case. Because I think they're waste. Because you have a settlement already and it begins after. And I think second, I wanted to pick on you guys for this fee shifting bylaw sort of quickly a little bit. I mean, if there was widespread sort of substantive changes and you had these fee shifting bylaws adopted in a widespread nature, I mean, wouldn't this exclude out the good cases? I mean, isn't this overreach to try and, in a developing situation, we don't know where Trulia is going to end up, we're still looking at it. I mean, why do we have to jump so soon to adopt these bylaws? Why not let things play out?
So I'll take the first crack at that. I mean, my view, Stephen, from the very beginning was that the ATP bylaw was a very bad example of how these bylaws are being written because it's over-inclusive, no question about it. And my view is it's inconsistent with Delaware's basic approach that we are an empowering and enabling jurisdiction to just create a mandatory prescriptive rule that in no circumstances could you ever have any type of fee shifting arrangement. So I would rather have the Court of Chancery adjudicating on a case-by-case basis. Now the argument is that if you adopt these things, no one's ever going to challenge them. So I mean, I think if you had a provision, maybe you did this legislatively, that said that no fees could be shifted in any case where a plaintiff challenged the fee shifting bylaw that the company had adopted, no fees could be shifted for that. That would mean you could challenge that bylaw on the grounds that as applied, it was going to be applied unfairly without risking fees being applied to you. And secondly, you could have tailoring of bylaws where, for example, they would only be in instances where you have filed in an inappropriate jurisdiction, contrary to what the exclusive forum bylaw requirement of the company is. That's an instance where it seems to me reasonable that if you do that, you ought to be required to pay the fees of the company if it has to then go through the expense of getting the case shifted to Delaware or whatever jurisdiction is the appropriate forum under its bylaws. So all I'm suggesting is that we went too far in one direction. We should have taken it in a little more incremental approach, the traditional, what I view as the traditional Delaware approach. Now, I'm not saying that every fee-shifting bylaw would be one that I think would be appropriate. I'm just saying they ought not be completely banned out. What about a charter provision where the shareholders of a company decided that they wanted to adopt, assuming you didn't have a controlling shareholder situation or something of that type? Maybe those are instances where you might want to create some exceptions and flexibility. I don't know whether you disagree, Tony.
Well, no, I don't. I'll just briefly follow on to that and say I think a lot of the discussion of fee shifting bylaws back when they were banned was somewhat limited. There was this concept of throwing the baby out with the bathwater. And you had a bathtub about the size of the Titanic that might have had a baby somewhere.
I think the problem is that fee shifting bylaw, people look at fee shifting bylaws as a sign that they throw out cases or we need to get rid of bylaws. I think it would actually change the method by which these things are litigated. And one of the things that I would encourage in a lot of the academic conversation on this, when I compare our papers to some of the others here, is our paper has a boatload of citations to documents that were filed in court, the actual litigating strategy and tactics that are used by the parties. One of the things that we mention is the substantially prevails language in the ATP bylaw, the criticism on that basis. Because people said, well, nobody will bring these cases if you bring 10 claims, you lose on 9, you win on 1, so now you have to pay the fees of the other side, even though you won. And to my mind, that says, well, no, under that regime, I'm going to bring my one strong claim. And if during discovery I find that there are other litigable claims, there's provisions in the Chancery rules to allow me to amend my complaint. What you're less likely to do, I mean, you talk to any Delaware defense attorney and you can have really fun conversations on the worst claims you've ever seen in a complaint. My favorite being the claim that the deal was underpriced because the directors were taking advantage of the weak financial crisis, which we all knew would be over quickly. And I was reading that complaint 3 years after the weak financial crisis was still ongoing. Under a fee-shifting bylaw regime, you're less likely to put that claim into the complaint to begin with.
I guess the thing that, look, I'm on the defense side of things, clearly, but the thing that, how would you tailor it to just deal with the very real statement that someone says, and let's like put Stuart Grant aside, who has lots of resources, but in some of the other big time lawyers, but let's just look at sort of a smaller firm, and they say, help me understand, cases, as a litigator, I've lost cases that I thought I should have won, and I thought I had a very good defense to, and yet we lost, and it just didn't turn out right. And so help me with the small firm that says, I think there's a real good claim here. I think we may be able to win this thing, but I sure as heck can't guarantee it. And I don't want to put my family's financial security at risk because I'm going up against, Gibson Dunn and Latham and Watkins and Morris Nichols and Richard Slayton and Finger, and the bill is going to be $20 million.
Well, if I can respond to that briefly, the same argument was made against the PSLRA. And the answer there was to let the market work. And, the percentage of cases that Milberg Weiss got up to, 80%. You would have concentration in the plaintiff's bar, presumably with firms merging, so that each firm would have larger resources. The other thing that I think, one of the interesting developments that we haven't talked about is the litigation funding development, with Peter Thiel funding the lawsuit against Gawker. There are, I understand now, some essentially, I don't know if you would call them hedge funds, but funds raising capital to finance litigation. And one could imagine such funds basically be coming into existence for plaintiffs in those kind of cases to say, I think I've got a strong case, you ought to finance me. And if that's a concern, then maybe the rules on litigation financing can be liberalized to permit that. But I don't think that should drive the fee shifting discussion, which in any event, fee shifting is a classic example of, I think of the Delaware bar protecting its interests, right? That if fee shifting had had the effect of reducing the volumes of litigation, this would have been bad for business.
Question about that, please.
What about if we do fee shifting, then putting the choice of state incorporation in the bylaws too? That way, if the plaintiffs are unhappy or the shareholders are unhappy with the choice, they can move the state of incorporation to a state they prefer.
Seems logical to me. I mean, I don't even agree with, I mean, I fundamentally, I know I'm preaching now against the interests of my own state, but I don't agree with the idea either that we have to file all these lawsuits in Delaware. I mean, I think Providence was right. I think the chancellor got it exactly right, and I think the bar overreacted to that by putting in this provision that requires every, if you're going to put it in, you got to put it in Delaware. I just think that makes us look provincial. That makes us look like we're self-protectionists. I disagreed with that, and I expressed my view, but yeah, let the shareholders decide.
Well, I don't want to reveal attorney-client communications, but I represented Providence and North Carolina Bank, a real community bank, et cetera. We predicted, we told them, I think you win. Did win. You can imagine how happy the client was when, after spending all that money to win the litigation defending its bylaw, which said that these claims need to be brought in North Carolina, we told them, oh, actually you've lost now because the legislature has come in and said you can't have a bylaw that says what you're saying. So that's there you hope inertia works, but unhappy person. So we have about 2 minutes left. Who's got a final, yes, sir?
How about Steve answering Hillary's question? Put it in the, I'm sorry, let the shareholders decide state of incorporation.
If I thought there was enough investor demand, if I thought, for example, that, I'll put it to you this way, I would be willing to go along with saying that it's not an excludable proposal under 14A8. Let them come in and propose a charter amendment. It would have to be precatory, obviously, but if you let them do it by 14A8 and say that it's not excludable.
They could currently do it by 14A8 as long as they make it precatory, right?
I would think so,
I mean, if they just
yeah.
ask the
Certainly
board
not
to
an ordinary.
consider the possibility of
It's no different than staggered
It's
board
right.
request.
Has anybody ever tried it?
Say on incorporation.
Has anybody ever, does anybody know if anybody's ever tried it with shareholder proposal?
Pretty sure it's been done, but I can't give you the site.
You can certainly have a precatory resolution. I would say that, and it's a whole other half-day seminar, that you would get a lot of people who would say, you know what, the board of directors does have a role here. They are informed in terms of issues like where we're best incorporated. They're perhaps more sophisticated, more informed, more knowledgeable. Why should we carve them out? I'm not espousing that role, that theory, but I think that would be strongly articulated at the Delaware bar level. And so my prediction would be that concept wouldn't go too far.
Well, I didn't say it would go far. I just think
Carl,
it
I
makes
kind of
sense
see
in
you
light
with
of the
the
other options on the table.
I'm thinking of a whole opportunity for Michal to piggyback onto Lucian's project and start a shareholder rights clinic that's proposing precatory provisions, suggesting that companies reincorporate in Nevada.
All right. Thank you all very much. Thank you, Greg. Great job. Thank you.